mention, madam.
Ah.
But I may be permitted to move an urgent application in regard to medical admission because it is a deadline admission. So once they fill up the seats, then my petition will become instruction.
Why are you coming so late?
My lord, because they have only just started allotted the seat matrix and they have the 52 seats which are given to unreserved. Actually, it should have gone to all the categories, but they have giving it only to the unreserved. So if your lordship doesn't interfere today, it will become infractions by tomorrow. Because once the seats are allotted, it will be very difficult to take it back. Because these are all deadline seats in the second round of counseling. We'll take a chance in the second half, my lord. We'll try to assist your lordship as far as I can, my lord.
Have you informed the other side?
Yes, we'll serve them a copy. We'll inform them, my lord.
Okay.
Otherwise, I would have waited till tomorrow, but medical admission, your lordship knows the urgency, my lord. That's why I have minimum. Your objection.
What in item number 23? You file an additional affidavit that is not tagged, but let it tag.
Additional affidavit.
Additional affidavit.
Okay.
Well, may I please also, well, this matter may be come up for motion either tomorrow or day after tomorrow, well, as per your lordship, my lord.
What is the urgency?
It is, my lord, regarding the appointment in the college, my lord. That's all. Day after tomorrow, my lord.
Okay, day after tomorrow.
Master.
This is regarding constitutional and school managing committee millot of a high school millot. It is constitutional millot, long back, but not taken any oath millot. So my pray it may 19 or 20 in roster.
No. For what? Motion?
Motion.
19. 19.
Wait, please, Rashid.
I beg to mention my. I beg to mention for lifting of a new matter, my lord, in motion, my lord, filed on the 5th of December, my lord. My lord, on 20, my lord.
Not 20. 19th.
But with regard to item number 1 listed before your lordship today, I have filed in my lord interlocutory application yesterday, my lord. That may be taken up together, my lord, along with the item number 1. It's an application for implement.
It was supposed to be disposed of today.
Lordship, my lord, can be disposed of, my lord. Lordship will hear me also, my lord, because if the order, my lord, goes in favor of the writ petitioner, that will affect our prospect in the, my lord, admission into the, my lord, PG course. There's large number of candidates who are not having the required continuous service of 5 years. So that is the issue, my lord. Whether
Okay.
the
You filed it.
lordship, yesterday we
This is the first item today.
first item, lordship. If
I will
in the meantime it comes, otherwise, lordship may
I'll
accommodate.
continue, my lord, let the application come. But otherwise, my lord, in fact, I would not have, my lord, objected to in an interlocutory applications for intervention. But since, my lord, I understand the arguments are almost completed. I was, my lord, supposed to only reply to the departmental counsel, my lord, what he had submitted. So I understand that your lordship would have proceeded for the judgment. And, my lord, it's an urgency of medical admission.
Okay.
So I'll start, my lord.
File without making the probable affected parties in the writ petition. So that
Okay.
is-
You get your-
Wait, please, your lordship.
With due consent from the petitioner, I beg to mention item 22. My lord,
Yes.
my senior is out of station. I pray that my is on Friday.
Friday will be difficult.
Maybe Thursday.
Master, court. Vacation court dates has been announced. How about 19th? That's Thursday.
Yes, my lord.
May I please?
My lord.
1 minute.
May I please?
Item 22.
My lord.
Okay, on request made on behalf of Mr. R. Majumdar, the Standing Council of Dhubri University. Released on 19th.
Wait, please, lordship.
Oh.
But I beg to mention for listing of a writ petition, my lord. Tomorrow or day after tomorrow, my lord. Writ
Fresh
petition.
matter?
My lord.
What?
My
is
lord,
that?
it's pertains, my lord, the petitioner challenged the notification of a NCT, my lord. So, my lord, there is some deadline, my lord, so that is why, my lord.
What date? When is the deadline?
My lord, the 31st, my lord.
Oh,
December, my lord. So, vacation will be started, my lord. So, my lord,
you'll be having a vacation court.
my lord, kindly on 19th at least, my lord.
This what? Okay, tomorrow we'll have it.
My lord. Obliged.
May I please, lordship? My lord, I beg to mention. Oh, withdrawal of one writ petition tomorrow, my. Withdrawal.
Why is it so urgent to withdraw it tomorrow?
My lord, better. inspection of my teeth.
Okay.
Tomorrow, my.
May I please, your
Oblige,
lordship?
ma'am.
I beg to mention for listing lordship, that similar matter is listed on 19 lordship.
What
Okay.
matter?
Lordship, the announcement of the tutorials, the other, all are matter are issued notice, lordship. The similar.
There's no urgency. It'll come up after the holidays.
May I please, my lord? Would you consent of the other side? May I please, my lord?
Huh.
Would you consent of the other side? I beg to mention item number 10 of the daily list, my lord.
Yes.
Today we are going to file our affidavit in opposition, my lord.
Mm.
May I pray for listing this matter after vacation, my lord?
Yeah, Sharma.
Yes.
Okay, heard Mr. M.B. Sharma and the counsel for the petition. Mr.
H. Burwa, on
H.
behalf of B. Gogoi.
H. Boral and counsel appearing on behalf of Mr. B. Gogoi and the standing counsel SSA,
SSA.
submits that affidavit in the opposition will be filed within this week. Stop. Accordingly, list the matter after winter, after the winter vacation.
May I please, your lordship?
Oblige.
My lord, item number 27 of today's list, lordship.
Yes,
My lord, I have an instruction to withdraw this petition with the liberty to file a fresh, lordship.
Mr.
M.I. Hussain, lordship.
Learned counsel for the petitioner, prays for withdrawal of this writ petition with liberty to file a fresh. Stop. Higher education, who appears?
R.K. Talukdar was appearing on the other day.
Mr. R.K. Talukdar, learned standing counsel, higher education, appears for the higher education.
আগৰ তাৰিখত
Okay, S,
As does.
S does.
As the.
The standing counsel appears for the higher education department. The petition is dismissed on withdrawal with liberty as per. Yeah.
obliged.
May I please, your lordship? Lordship, item number 36. We want to withdraw this petition, lordship.
Symbol withdrawal.
Lordship.
Your good name?
D. Kolita, lordship. Liberty may be given, lordship.
Mr. D. Galita, learned counsel for petitioner, prays for withdrawal of this writ petition with liberty,
Yes, lord.
with liberty to file afresh. Secretary, Mr. S.M.D. Chishti, learned standing counsel, appears for the secondary education department.
36.
Writ petition is dismissed on withdrawal with liberty as paid for. Yeah.
May I please, your lordship? I beg to mention item number 9, lordship.
Ah,
Lordship, senior engaged counsel, Mr. S.H. Sigdar is out of station, lordship.
yeah.
Therefore, matter may kindly be taken after vacation.
On request made on behalf of Mr. S.S. Shikdar and the counsel for petitioner. List after the winter vacation.
May I please, your lordship? Lordship, I beg to mention item number 3. My senior Mr. H. Buragohai, he is out of station. Kindly matter may be taken up after vacation.
Okay, on request made on behalf of Mr. H. Buragohind and the counsel for petition. List after winter vacation.
Item 1 of daily list, motion.
May please, Lord. My lord, on the
So
last.
your
occa-
basic ground is that since the notice was issued prior to the coming to force of the amended rules,
Correct.
the old rules should prevail.
Yes, correct.
Okay.
And my lord, in fact, my learned friend, not on the last occasion, he has made some submissions, my lord. So I would like to address my lord on those points. The first, my lord, basic submission of my learned friend was that the eligibility has to be considered on the date, my lord, last date of application. And to this regard, my learned friend, my lord, had relied on Pori Chaudhury's case, my lord, of this honorable court.
Mm.
And to that effect, my lord, Supreme Court judgment of 2005 9 SCC 779 is referred in para 30. So that judgment, my lord, has already also been referred to by my learned friend. And the other submission was that the notice dated 14/11/24 and 26/11/24 of the DAME, my lord, Director of Medical Education, Assam,
Page.
saying that, my lord, page, my lord, this is their argument. This is one page 36, my lord. Here, what is relied on? My learned friend says that the Assam Medical College of Assam Rules 21 amended up to date. This has been mentioned. And the argument is, my lord, this is not under challenge. I'll respond to all this, my lord, submissions of my learned friend. Firstly, my lord, the Pori Chaudhuri of this honorable court.
Let us see the judgment.
Yes, sir. That, my lord, my learned friend has on the last occasion, he has placed before your lordship's, my lord, the judgment. In fact, this is also a judgment wherein, my lord, after the examinations are over, the rule which was amended was sought to be applied. And in that context, my lord, this honorable court has held that on the date of the application, if you are eligible, you cannot be rendered ineligible by a subsequent amendment. Now, I take your lordships to para 30. The Supreme Court in Dolly Chanda versus Chairman JE reported in 2005 9 SCC 779 had declared that while applying for any course of study, the person must possess the eligibility qualification on the last date of application, last date for application. The period for application for this year's admission was scheduled during 31/17 to 1/3/17, and hence the eligibility for the petitioner must be with reference to the last date of application, i.e. 1/3/17. Therefore, the admission must be granted on the basis of the norms prevalent on the date when the aspirants could last apply, and logically, therefore, the new rules cannot apply for admission in the current session. So essentially what the Honorable Court has held, that on the last date of application, if you are eligible in terms of the rules holding the field, then by way of the subsequent amendment, you cannot be rendered ineligible. Essentially, my lord, this is the ratio. Now, if your lordship comes to the Supreme Court judgment, my lord, this was rendered in a totally different context. I'll, my lord, place that Supreme Court judgment. 2005 9 SCC 779. Here what has happened, my lord? There was the joint entrance examination 2003. Now, my lord, in terms of the, my lord, the brochure, information brochure of JE 2003, my lord, certain seats were reserved for the, my lord, children or widow of personnel of armed and paramilitary forces. And that brochure, my lord, indicated that if there is a permanent disability of the parents, my lord, out of some war, my lord, or peacetime operation, then the candidate would be entitled to. Now, what had happened, my lord? This particular petitioner, his father was permanently disabled. And while applying, my lord, the certificate which was provided by the competent authority that contained some defect. Now, on account of such defect, her, my lord, case was rejected, despite, my lord, having, my lord, secured a seat in the select list. Now, eventually, she, my lord, the father procured, my lord, another certificate from the army authorities, saying that he is permanently disabled. But that was not, my lord, considered. Eventually, my lord, what the High Court says, that at the time of the filing of the application, you did not submit your certificate, or rather it was defective. So therefore, my lord, the authority, medical authority was right in rejecting your application or rejecting your seat. Eventually, matter went up to the Supreme Court, my lord. Now, this is, my lord, the premise on which, my lord, the judgment was rendered. Now, the Honorable Supreme Court says that it is not the certificate which is crucial. What is crucial is on the date of the application, whether he was eligible or not. And on that count, my lord, the rejection was set aside and she was directed, my lord, to have a seat on the next, my lord, session. Even, my lord, the earlier session, my lord, had completed. So in that context, my lord, I take your lordships to para 4. The writ petition filed by the appellant was dismissed by the High Court on the ground that at the time of counselling on 7/7/23, the certificate furnished by the appellant did not bear any testimony that her father, being a personnel of armed paramilitary forces of Odisha, had been disabled in action, and consequently in terms of clause 2.1.4 of the information brochure, her claim that she belonged to the reserved MI category had not been established. Now, para 5, my lord. In the counter affidavit filed on behalf of the respondent, it is admitted that the appellant had secured rank in serial number 20 in the medical stream in JE in 2003 in the reserved MI category. The stand taken is that, as in the certificate produced by the appellant at the time of counseling on 7/7/23, it was not mentioned that her father was a disabled personnel of the armed paramilitary forces. Her candidature was rejected. It is further pleaded that since her candidature was rejected due to her ineligibility, she was not allowed to appear in the second counseling. The fact that candidates who have secured lower rank than the appellant in the reserved MI category have been given admission is not disputed. Now, your lordship will come to para 8, my lord. In the my lord, middle portion, my lord, that may not be necessary. Now, what is the principle, my lord, in such circumstances has been explained by the, my lord, Honorable Supreme Court at para 8. This principle was explained and applied in so-and-so 1982 SCC 752. The controversy here related to admission to a postgraduate course in medicine. The relevant rule provided for addition of 10% marks if a candidate possesses a diploma in the relevant subject or subspecialty, and this benefit could be given only if the candidate's success in the diploma course was brought to the knowledge of the selection committee before completion of selection in an authentic or acceptable manner. The prospectus provided that the attested copies of statement of marks and other documents should be attached with every application. 3 such candidates were given admission who had not attached the certificates of having passed the diploma along with their application. Their admission to postgraduate course was set aside by the High Court on the ground that their application wherein they claimed the benefit of diploma were liable to be rejected as the requisite certificate had not been attached. This court, speaking through Krishna Iyer J, reversed the judgment of the High Court and held that the admission to the candidates had rightly been given as they had in fact passed the diploma before the date fixed. The relevant part of 20 and 24 of the judgment where these principles were highlighted are being reproduced here and below. I will not go to that part, my lord. And eventually, in this case, what the Honorable Supreme Court has held at para 10, my lord, in the present case, the appellant had qualified in the JE 2003, but the said academic year is already over. But for this situation, the fault lies with the respondent who had adopted a highly technical and rigid attitude and not with the appellant. We are therefore of the last line is, my lord, ineligible. Then your lordship will come to State Medical College in the current academic year. The appeal is accordingly allowed with cost. The judgment and order dated of so-and-so of the High Court is set aside. The respondents are directed to give admission to the appellant in any one of the state medical colleges forthwith. In case seats have already been filled up, 1 extra seat shall be created for her. So, my lord, my respectful submission, this case, my lord, which is referred in Pori Chaudhary, it is altogether on a different premise. Now, what the Supreme Court says, that if you are eligible on the date of the application, even if you don't provide the certificate to that effect, but the fact remains that you are eligible. So therefore, my lord, here the question comes, whether on that date, when, my lord, the application was filed by the petitioner, whether she was eligible or not. In my respectful submission, she was eligible because the rule holding the field on that date was unamended rule of 2021. In terms of that rule, she had already, my lord, to her credit, my lord, the service of 5 years or more. And in terms of the rule, my lord, cut-off date 31st May of, my lord, 2024, the counting, my lord, if we count, then to her credit, she has 5 years and 7 months. So essentially, here it is not a case whether the petitioner was eligible or not on the date of the application.
No, according to you, when is the date?
My lord, according to me, the date when the selection process starts is the first notice of the medical, my lord, board, that is November 23.
1 minute.
My lord.
The first notice.
If your lordship comes to the writ petition, the first notice, my lord, is 9/11/23, page 29. Now, here, my lord, the scheduled date is 3rd March 24, the date of NEET PG 24. And your lordship will see the amended rule has been brought into force on 13th March 24. The scheduled date is, my lord, of the examination is 3rd March 24. Due to inadvertence, my lord, there was the examination was rescheduled. And had on this date, the examination would have conducted, there would have no occasion on their part, my lord, to apply, my lord, the amended rule. My lord, my first respectful submission is,
According to the respondents,
my lord,
this notice is only tentative,
this notice is tentative, absolutely correct.
and that the date on which it will be counted will be the information bulletin,
Yes,
that is Annexure A
annexure,
of their
yes, yes,
of their
correct.
affidavit in opposition.
I'm coming to that.
Oh.
My lord, page 62, this is the information, my lord, brochure or information bulletin relied on by the, my lord, the respondent. Now, the date online submission of application, my lord, is indicated as 16 April 24 to 6 May 24.
Hmm.
And secondly, your lordship will see the examination date. This is, my lord, indicated as 23rd June 24.
Hmm.
Now, relying on this particular date, what the submission of the department is, my lord, this is the date which is required to be reckoned to be the eligibility criteria. They have, my lord, relied on this particular date of, my lord, submission of application. So according to them, the last date is 6th May 24, according to them. And the another, my lord, argument is that the date, my lord, in the first notice of the board being tentative, so therefore it cannot be relied on. Now, if your lordship sees, my lord, the date of the information bulletin also, 23rd June, that was also not final. Examination was also not held on this date. So this date also becomes tentative, my lord. Examination was held on 11th August of 24.
No, when did the online submission of applications start taking place?
On that day.
My lord, here it makes it clear 16th April 24 to 6th May 24.
When did you make your application?
My lord, within this date, it is admitted. What I'm trying to say, my lord, my respectful submission is, here is not a case which your lordship is called upon to decide my eligibility, so as to come, my lord, to the last date of application. Here is a case, my lord, your lordship has to test, my lord, the application of the amended rule in terms of the Constitution Bench judgment. The Constitution Bench judgment says that the initiation of the selection process would be from the date of the notice, not from the date of the application. If I take your lordships again, my lord, to the my lord, Constitution Bench judgment, it's very specific, my lord.
Yes.
My lord, I'll directly, your lordship will recollect that this was a reference before the 5 judges bench. My lord, in view of, my lord, two conflicting judgments, one, my lord, in the Manjusri's case and other in Subhash Chandra Marwa. Manjusri, my lord, says that during the, my lord, ongoing selection process, the amendment of the rule is not permissible in term, my lord, so far as the basic qualification is concerned. Marwa says, my lord, that is permissible so far as, my lord, the manner and method of the selection is permissible, not affecting the basic, my lord, criteria or the qualifications. So therefore, whether Manjusri was correct or not, or whether Marwa was corrected, this was tested by, my lord, by this Constitution Bench judgment. Now, I take your lordship to verify, this would be necessary to understand, my lord. In various judicial pronouncements, the law governing recruitment to public services has been colloquially termed as the rule of the game. The game is process of selection and appointment. Courts have consistently frowned upon tinkering with the rules of the game once the recruitment process commences. This has crystallized into an oft-quoted legal phrase that the rule of the game must not be changed midway or after the game has been played. Broadly speaking, these rules fall in two categories. This is important, my lord. One which prescribes the eligibility criteria, essential qualifications of the candidates seeking employment, and the other which stipulates the method and manner of making selection from amongst the eligible candidates. So manner and method, my lord, which is sought to be amended, if it does not touch upon the basic qualification, that is permissible. I take your lordships, my lord, to the conclusion part, what eventually the reference court has held. Your lordship will come to page 25.
Yes.
Recruitment process commences from the issuance of the advertisement, calling for applications and with the filling of a vacancy. It does not say when you submit the application. It says when it is initiated, my lord. My respectful submission, it was initiated by the, my lord, Central Board in November 23. And therefore, the date of the application cannot be reckoned, my lord, for determining my eligibility.
And when was this bulletin?
Bulletin was published, my lord, that date is not here.
But in the month of April, first week of April 2024, my lord.
How do you know that?
My lord, because it was uploaded in the official website and respond number 2 he is appearing, my lord, Central Government Council. Mr. K. Gogoi was appearing last time, my lord, but he can ascertain, my lord. But certainly, my lord, otherwise also because date has been notified, last date of submission of application is 16 April 2024. Just before that, my lord, it has been published, my lord.
My lord will again come to para 13 before proceeding further in respect of the conclusions, my lord.
Para 13.
Para 13 of this, my lord, the judgment, page 11. This, my lord, is more precise and candid. The process of recruitment begins with the issuance of advertisement and ends with the filling up of notified vacancies. It consists of various steps: inviting applications, scrutiny of applications, rejection of defective applications, elimination of ineligible candidates, conducting examinations, calling for interview or viva voce, and preparation of list of successful candidates for appointment. So in between, my lord, there are various stages. Submission of application is one of the stage. And therefore, the submission of application cannot be reckoned, my lord, to be the date when the selection has been initiated.
It will be the day of advertisement.
Absolutely, my lord. And here, my respectful submission is when the notice, my lord, first notice in November 23 was, my lord, issued by the, my lord, National Board, that is the date. And in this respect, my lord, I have already drawn your lordship's attention, my lord, this particular proposed, my lord, submission or contention has not been controverted by the respondent. I take your lordships again to para 20 of my application, my lord. This is admitted by them. It is hit by non-traverse, my lord. The doctrine of non-traverse. They have not, my lord, categorically denied this particular, my lord, contention in para 20, that it starts, my lord, from the date when the notice was issued in 9/11/23, para 20, page 16, my lord, of my writ petition. That it is stated that the Medical Colleges of Assam Rule 24 is not applicable in the present case in connection with the petitioner admission, as the process of admission was started much before the rules of 2024, while 2021 rule was in force. An initial notice was issued on 9/11/23 by the National Board of Examination, Medical Sciences, New Delhi, fixing of date PG 24, and the amendment of Rule 24 came into force much after the process started of the admission of NEET PG 2024. Therefore, the case of the petitioner may be considered under Rule 7, Sub-Rule 1C of the Rules 2021. So my submission was the amended rule will not apply, since, my lord, this amended rule was holding the field when, my lord, the selection process was initiated. Now your lordship will see what they have, my lord, stated against, my lord, this particular contention in their, my lord, counter affidavit. There is absolutely non-traverse. Your lordship will come to para, my lord, 9. That in view of the statement made herein above, all other statements made in para 19, 20, 20 will include my 20, my lord, 21, 22, 24, 25, the writ petition are being denied herewith. There is a denial. But where have you controverted that this is not the date? The first notice is not the date whereby the selection has been initiated. Absolutely not denied. And so far as the other paras are concerned, my lord, they say that since, my lord, the amendment had come into force prior to filing of your application, therefore it will apply. But they never say that the initiation was not in November 23. And secondly, my lord, another, my lord, more importantly, there is another judgment I will place before your lordship. My lord, then retrospective amendment, my lord, is permissible, provided that the rule permits. It must expressly provide that you may have a retrospective effect. Now, if your lordship comes to the amended rule, my lord, a clear prospective effect has been given. Page 52. This is the amended rule, 13 March 24. And from this date, it will apply prospectively. Serial number 2, short title and commencement, they shall come into force from the date of their publication official gazette. So meaning thereby, from this date, my lord, it will have an application. You cannot apply retrospectively to a selection process which was already initiated in November 23. And in this regard, my lord, if your lordship considers the Supreme Court judgment, it is very clear that rule must permit. Etu deduction. 2005, 4 SCC, 154. Para 14, my lord. The High Court has committed an error in holding the amended rule was operative. It, as has been fairly considered by learned counsel for the respondent, one applicant, it was the unamended rule which was applicants. Once a process of selection starts, the prescribed selection criteria cannot be changed. The logic behind the same is based on fair play. A person who did not apply because a certain criteria, for example, minimum percentage of marks, can make a legislative grievance in case the same is lower, that he could have applied because he possessed the said percentage. Rule regarding qualification for appointment, if amended during continuance of the process of selection, do not affect the same. The continuance of the selection process will not affect by the amended rule. The earlier rule holding the field will apply. This is because every statute or statutory rule is prospective, unless it is expressly or by necessary implication made to have retrospective effect. There must be a, my lord, express provision that it applies retrospectively. Here, my lord, the selection process having been initiated in November 23, the rule ought to have made it clear that it will have a retrospective effect. There is no such, my lord, express provision, my lord. Unless there are words in the statute or in the rules showing the intention of affecting existing rights, the rule must be held to be prospective.
Yes.
If the rule is expressed in a language which is fairly capable of either interpretation, it ought to be considered as prospective only. Even by way of interpretation, you cannot have a retrospective effect. Even two meanings are, my lord, capable of being interpreted. Even then, you are required to give a prospective effect. This, my lord, part, para 14 of the judgment is very clear. Now, coming back again, my lord, to the Constitution Bench judgment, so I have already drawn your lordship's attention to para 13, which says the process of recruitment will start from the date of advertisement. In between, there are various stages, my lord, including the stage of submission of the application. So that date of submission of the application cannot be reckoned to be the date when the election ballot selection process started, because Supreme Court in para 30 is absolutely clear. Commencement from the date of advertisement. Now, if your lordship comes to the conclusion part, para 42, we therefore answer the reference in the following terms, page 25, my lord, of the judgment. Recruitment process commences from the issuance of the advertisement, calling for applications and with the filling up of vacancies. Number 2, eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extent rule so permit, or the advertisement which is contrary to the extent rule so permit. Even such change is permissible under the extent rule or the advertisement. The change would have to meet the requirement of Article 14 of the Constitution and satisfy the test of non-arbitrariness. Even if, my lord, it is applied in a retrospective manner, permitted by the rule, even then, your lordship's, my lord, would strike it down if your lordship finds that it's arbitrary and do not satisfy the requirement of Article 14. Even then, my lord, even if the rule permits. And when the rule does not permit, my lord, when it does not expressly provide, your lordship has to interpret, it will have a prospective effect, my lord. And meaning thereby, in the present case, you have to apply it on the next session, my lord. Not in respect of the present session, which has already been initiated by the advertisement of November 23. And para 3, my lord, the decision in Manjusri's case, my lord, is held to be good law, which says, my lord, during the ongoing process, in respect of the basic qualification, you cannot amend the rule and apply therein. So, my lord, my respectful submission is the stand of the department that the date on which the application was submitted has to be reckoned to be the date for the eligibility criteria is misconceived. And such a contention, my lord, it's run contrary to the Constitution bench judgment. Submission of application is one of the various stages, my lord. That does not initiate the, my lord, selection process. Selection process starts from the first date of notification or the advertisement. And here, admittedly, my lord, the date is November 23, which is not denied by them.
Okay.
So, my lord, this is my humble submission, my lord.
Yes, Saikia, where is your IA? IA has come? No, he has already submitted, isn't it? Yeah, you can give your short submission, Bora.
Yes, my lord.
That your thing is that the selection process starts from the issuance of the bulletin.
Bulletin, because the
But in
November,
your affidavit, it is said that it will start from the day of application.
yes, my lord.
Correct. When was the bulletin issued?
Bulletin, my lord, because in the website exact date we could not find, my lord, when it was uploaded. But the probable date is that it was uploaded in the first part of April 2024. And exact date, my lord, the advocate appearing for the respond number 1, they can.
Who is the respond number 1?
Respond number 2, my lord, the National Board of Entrance Examination, my lord. Respond number 2 is, my lord, National Board of Examinations in Medical Sciences. Mr. K. Gogoi was appearing on last occasion.
Where is
my lord.
Gungoi? Get him.
So, my lord, my contention is that, my lord, even if, my lord, if we consider the information bulletin to be the advertisement, so it starts from the publication of the information bulletin only, my lord. And the amended rule came prior to the publication of the information bulletin. And in terms of the judgment, as I have referred on last occasion, my lord, Supreme Court judgment 2019-10 SCC page 20.
1 minute.
Yes, my lord.
2000.
1910 SCC page 20, my lord.
Oh, 19.
Bidhi Himmat Kataria, my lord. If your lordship, there are 7. Page 20. There are 7, my lord.
Yes.
If your lordship comes to the last part of para 7, my lord. Therefore, the relevant date, your lordship, therefore, the relevant date for considering the essential eligibility criteria as per Appendix H shall be the date on which the candidate petitioner sought admission in the MBBS course under the PWD quota. So, relevant date is the date when the petitioner seeks admission. So that is the date of submission of last date of submission of application, my lord. That is my contention. And because last date of submission of application was 16 April 2024, my lord. And amended rule came prior to that, my lord, on 13/3/2024. And second, my submission is that, my lord, the educational notice which has been published on 14/11/2024. In that educational notice, my lord, it has been specifically stated that page 63, my lord. Second paragraph, my lord. The first round online counseling for admission into 50% postgraduate seats in the government medical colleges of Assam and BBCI Guwahati under Assam State Quota for session 2024 will be held as per the Medical Colleges of Assam Regulation of Admission into Postgraduate Degree and Diploma Courses Rule 2021 amendment up to date. So it says that the amended rules will be applicable. Then, my lord, the next admission notice is there, my lord, which was published on 26/11/2024, page 65, my lord. Page 65. Here also, my lord, it has been specifically stated. After verification of the documents, the selected candidate shall have to get admitted in the respective allotted institution on 4/12/2024 or 5/12/2024 with following terms and conditions, failing which their allotment will be cancelled. So number one condition is that all admissions shall be provisional and will be subject to fulfillment of all the requisite eligibility criteria as per the Medical Colleges of Assam Regulation of Admission into Postgraduate Degree and Diploma Courses Rules 2021 amendment up to date. So it also specifically notified that the amended rule will be applicable, my lord. And petitioner, my lord, never raised any objection regarding these two educational and admission notice, my lord. She participated, my lord, without raising any objection, my lord. And when she has been found ineligible because of non-completion of 5 years of continuous service. Now only she is raising this issue. All along she was aware that amended rule will be applicable. And accordingly she participated, my lord. Only at the last moment when the continuous service, probably at that point of time, she was not aware regarding the continuous 5 years of service, my lord.
Yes.
So these two are my basic submissions. Firstly,
grounds.
yes, my lord.
But only one short reply. Hello, this is not a case of eligibility criteria. This is a case of amendment of a rule in a
Application of rule.
retrospective manner. These judgments are with regard to eligibility criteria. And I'm relying on a constitution bench whether you can, my lord, apply a, my lord, rule by amending in a retrospective manner. That is the question before your lordship, my lord.
Your IA?
My lord, I hasn't read, my lord, the copy is there, my lord.
You've got a copy?
My lord, we are qualified, my lord, so far as the my lord, the NEET exam is concerned, and we are also, my lord, shortlisted for the state quota. Now the, my lord, what from the order, my lord, that was passed in this as an interim order, my lord, dated 3/12/2024, my lord, it appears, my lord, the writ petitioner did not have the continuous 5 years of service. The earlier rule, my lord, 2021, the word continuous was not there. And in the 2024, the rule which came, it has given the word continuous. So therefore, she is disqualified. Now the controversy, what I have been heard, my lord, from both sides, my lord, whether it will be, the date will be, my lord, whether this amendment came in force in March 2017 would be applicable in the instant case. For that, my lord, the writ petitioner is saying that the date of notice which was issued by the National Board for NEET exam is the date. And whereas the rule, my lord, will find the rule which has been annexed here to, my lord, in page 39.
Of the writ petition?
Of the writ petition, my lord. I have taken this petition from the respondent, my lord, so at glance, my lord, whatever I could do. This is basically for this.
Okay, well, before we hear you, now how are you affected?
I'll be affected because, my lord, the question of preference will come and the question of, my lord, the allotment of seat.
Who's the applicant here?
Not only the present writ petitioner, but there are several numbers of, my lord, candidates who are in the list and above us. If they get into the admission, then, my lord, the prospect for us will be, my lord, bleak in the getting into the.
Now let us see your application. What is your ground?
Production. Paragraph 3, my lord. That if the candidate as that of the opposite party number having not fulfilled the norms of completion of 5 years or more than 5 years of continuous qualifying service as doctor as mandated by the said amendment rule 2024 for getting into the state health quota occupied the seat of the illegal candidate under the SSP, then the applicant would be highly deprived of the rightful opportunity. Because if they are weeded out, then my prospect will be, my lord, above, my lord, the choice of the department will be, my lord, allocated.
No, you have to establish yourself that you are going to be affected if the petitioner is allowed to take his
because, my lord,
admission.
admittedly in the qualifying, my lord, examination, my lord, my marks are less, but I am shortlisted for the state health.
Okay,
So if
where's
the-
that list?
But the list,
Have you annexed, Talukta?
No. Because this copy has been received by me now. My lord, in fact, what
No,
is
in your writ petition?
writ petition? No, my lord. I have only, my lord, annexed my select list, the part of the select list, my lord.
That part.
Yes. My lord, once your lordship decides, rightly, my lord, this side or that side, then only, my lord, their right will crystallize. Now, my lord, everything, my lord, is in a premature stage. How come any right comes, my lord? And there are so many hundreds, my lord, hundreds of candidates, not only they, my lord. Your lordship has to decide regarding the, my lord, retrospective amendment. Then only, my lord, certain rights will crystallize. Here, everything is vague, and my now, my lord, the admission is at, my lord, stake due to this, my lord, implementing application, without, my lord, any locus, my lord, on their part.
well, the copy has not been annexed, my lord, but simple, my lord, the reply to him.
Bora, where is the state health quota select list? You obtain it today itself. We'll have to dispose this matter.
Yep.
Even if I implead you,
Look.
even if this court permits to implead you,
Look.
we'll have to dispose this matter today.
Lord, yes, yes, my lord. Only the legal.
Because tomorrow is the or today the date of admission.
Date of admission it is going on, my lord. Counseling is going on, my lord. Date of admission.
No, you were expressing some urgency on
Yes,
the
my
other
lord,
day, isn't it?
No, it is urgent, my lord. Because, my lord, as per
Today,
the-
your lordship will decide it, my lord. This way or that.
No, nothing factually, my lord, I'll be submitting only on the law and the documents what they have, my lord, appended to the report. So therefore, my lord, my affidavit would not be that way referred.
Okay.
My lord, online counseling for the second round is over, my lord. It was from 12/12/2024 to 14/12/2023.
Okay.
So next, my lord, online filling of choices is from 15/12/2024 to 19/12/2023.
Okay.
Online voting of choices on 19/12/2024 itself. And processing of seat allotment on 20/12/2020.
Okay.
Second round counseling is open. My lord, we are giving the list. My lord, list is with us.
You have the list.
Yes, in the digital mode, man.
Oh. That will take up after some time.
His
No.
serial number in the merit list is 574 and mine is.
What you can do, instead of if it's voluminous,
No.
you take out the page that concerns the petitioner.
Yeah.
Serial number.
Yeah.
And the applicants.
Yes.
They should give the serial number,
Yes,
my lord.
our serial number is, my lord, that is there. Yeah, that is, we have mentioned. 1756 1308 167 1813
574.
and repetition is 570
74.
570.
Much
He's
above. Much above.
He's above.
No.
But
You are
74.
and you are
my lord, I am after the, my lord, 1000. We are much below. But thing is that the kind of, my lord, candidate of his nature are many in the top, in the above. If this repetition succeeds, my lord, in that case, my lord, all those persons who are otherwise not eligible under the rules will also get the similar benefit. And our perspective behind that is the only thing. And whether, my lord, this.
how many seats are there? Still held quota?
It is indicated in the rule, my lord, 40 seats. Health quota. State health quota. This is a case of state health quota. 40 seats.
40 seats.
My lord.
Okay.
7. Rule 7. Page 42. Lordship can decide it. Ranks are clear, my lord. There's my lord position in the select list is given.
I'm below.
Much below, my lord.
That's what I said. I'm below. But this kind of the candidate having this, my lord, the shortage of 5 years continuous service are many. So if he succeeds.
How many are there?
Yes. They have to select that one.
This data you should have it so that when this court gives a decision, because see now the Psychia's party has come.
Yes, madam.
They want an implement.
Yes, ma'am.
Correct.
Yes, ma'am.
Now what the they are saying is that just like the petitioners, there are a few above them
Yes, my lord.
who are having less than 5 years of continuous service. If petitioner's case is allowed,
Yes.
they will all go.
Yes.
If petitioner's case is not allowed,
Yes.
all those others also will go and they have a chance.
Yes.
Now let us see whether they will come under the 40 for the process of for the question of impleting them. Otherwise, there's no point in delaying this matter.
My lord, my submission
Yes, my
is,
lord. Yeah.
my lord, my submission is on the either, my lord, side, on the, if your lordship even rejects, suppose rejecting your application, that will be decided by the DME, whether they come or not. As on date, my lord, no right has been crystallized. And lordship will see, my select list at, my lord, 574 is not under challenge. They have to come, my lord, by way of a fresh writ petition. How come by a, my lord, respondent, they can have a, my lord, relief in my case, my lord? That is not permissible.
We have already been called for 42nd.
We have sufficiently selected.
Huh?
That's selected.
We have already called for.
Yes. Select list not under challenge.
We are not challenging this. But
Yes.
The whole thing is that whether you have the 5 years continuous service.
That your lordship will
Now
decide,
the
my lord.
Legal question that has been arisen, they said that since the amended rule came in March 2017, so that will not be applicable. The rule of 2021 will be applicable, where the continuous word was not there. It was only the regular service of 5 years. Now, even if the rule of 2021 firstly taken into consideration, lordship will file, his cutoff date of 5 years is on the 31st May, the year in which the admission is, my lord, to be given, not on the date of when, my lord, the NEET will publish an application for inviting application for qualifying the, my lord, NEET exam. My lord, one may appear in the NEET exam, may not, my lord, go for the medical, my lord, this admission. That is a separate qualification altogether, my lord. And the state government has taken a my lord, procedure that they will not individually see the qualification of the candidate. Whatever is, my lord, given in the they are ranked in the, my lord, this NEET exam, that will be applicable. So therefore, in the eligibility condition also, it has been mentioned, my lord, that the person must qualify the NEET exam. So that is only that much, my lord. But so far as the admission part is totally different, my lord. So admission has come, my lord, subsequent to the amendment routes.
Where's Gogoi? See, he has to take one very vital instruction. This court wants to know.
Now this eligibility, my lord, page 41, eligibility of the candidate for appearing the counseling for admission against the state quota. Page 41, my lord, rule 5, the following condition must be fulfilled by the candidate applying for the state quota. The candidate must obtain the qualifying marks in entrance examination as notified by NMC, Government of India, for the respective session. So that exam is totally different, my lord. Now the condition is that he must be qualified under that exam. Now this rule, my lord, 7C, the applicant must complete the required period of service in rural area on or before 31st May of the year of admission. My lord, the admission, my lord, the advertisement may be, my lord, of the, my lord, for notice for admission maybe in 2023. But if the admission has been effected in 2024, that will be the date. This 31st May. This year of admission, not for the, my lord, notice of or the advertisement for my lord, admission.
Okay.
So it is 31st
Let
May.
Gogoi come. We'll take up after some time. Meantime, you can take some instructions.
Yeah.
You be around, Talukar?
Well, I'll be here. Well, since I pray that since it's a medical admission, lordship will dispose it of today, Mal. Otherwise, every, my lord, passing day, my lord, is crucial for me, my lord.
Yes.
Obliged, my lord.
That I'm going to dispose
My
of.
lord, my lord. Correct.
Two,
Wait, please, Lord.
Hmm.
But in this case, my lord, actually, I was supposed to file an additional affidavit.
Yes.
My lord, that could not be filed, my lord. So may I pray for some more accommodation matter?
Mr. Ishaq, learned counsel for the petitioner. Prays for how much time?
4 weeks.
Huh?
4 weeks. 4 weeks.
4 weeks.
My lord.
To file additional.
Because, no, my lord, actually, what happened, my lord, all are saying they court, my lord, but uh, Honorable Court, my lord, in the occasion, my lord, had directed the petitioner to obtain instruction from the secondary council, my lord.
Hmm.
So, my lord, that RTA application, my lord, that information has not yet issued by the
Okay, prays for 4 weeks time to file additional affidavit. To file an additional affidavit. As directed by this court on 1/10/2024.
Right.
Stop. Praise the Lord. List of the 4 weeks.
Nice. I am obliged. 4,
May please your lordship.
Hmm.
In this matter, my lord, as per last order, the respondents have to file their response.
Hmm.
My lord, in this matter, my lord, my colleague S. Bora was appearing, my lord.
Hmm.
However, he's on leave, my lord, and I'm instructed to say, my lord, notice is yet to be issued, my lord.
Yes, my lord, notice has not been
Notice
issued,
may
my
go
lord.
fast.
Already 1.5 years left, my lord.
Yes, sir.
Okay, heard M. Cycle and the counsel of the petition. Issue notice. Elementary. Mr. G. Bekul, understanding counsel elementary education. Request for the response number 1, 3.
One and three, man. I am representing 1 and 3.
1 and 3.
2, 4,
And
5 and 6.
Mr. S.R. Raba, understanding counsel BDC.
My lord.
Appears for respondents 2,
2, 4, 5 and 6.
Notice on response of however extra copies. Respondents are allowed to file affidavit. List after 4 weeks.
Available. 5,
May it please your lordship. Lordship, the petitioner before your lordship is a PWD candidate, my lord. Who, my lord, as per an advertisement dated 30/12/2018, my lord, page 18 of the writ petition, my lord, applied for the post grade 3 and grade 4, my lord.
Hmm.
Thereafter, my lord, merit list was published, my lord. Page 37 of the writ petition, my lord. In that merit list, my lord, the petitioner secured the rank of 942, my lord.
Okay.
The petitioner was enlisted.
Let us see that advertisement again.
Advertisement is at page, my lord, 18. And moreover, my lord, on 1/10/2024, my lord.
1 minute.
Page 18, my lord. This advertisement was issued by, my lord, Office of the Chairman, State Level Police Recruitment Board, Assam, my lord.
Okay.
And my lord, on earlier date, my lord, on 1/10/2024, my lord, some instruction were sought from the respondent council, my lord, respondent number 4, my lord. And my lord, also the matter was filed on 15/9/23, my lord. Till date, notice has not been issued in this case, my lord. So I am praying for a notice also, my lord.
1 minute. Yes, who appears on the other side?
It is respondent number 4, my lord, who is answerable. Government advocate, my lord.
Have you filed your amended cost title?
My lord, we have filed an IA, my lord, which was disposed of, my lord, directing the registry to implement respondent numbers 4 as a party, my lord. On 1/10/2004, my lord, the IA was disposed of.
1 minute. There's no implement of respond number 4.
There is, my lord. If my lord will peruse the order dated
That
1/10.
order is there, but there's no implement. Nothing has been changed. You file an amended cost title.
Okay, I will file it, my lord.
Third, Mr.
Yes, Upadhyay, my lord.
Yes, Upadhyay, then counsel for the petition. Stop. In view of the order dated 1/10/2024, passed in IA within bracket civil number 2625/2024. The petition is directed to file an amended cost title. Stop. Huh? Issue notice within 1 week from today. Issue notice. Karbi Anglong
I'm appearing
MS
as Kempalot.
S.
Kemprek.
Kemprel and Standing Council KAC appears for the respondents.
Number 1 and 2.
One and
Lordship,
two.
respondent number 1, Tarbiano Autonomous Council represented by Chief Secretary, but we don't have a Chief Secretary. We will be represented by Principal Secretary.
Then everything is wrong.
My lord, I may be allowed to correct it, my lord.
You can't correct it. You'll have to file an IA for correction. You'll have to file an IA for correction.
I'm going to file it now. Let me file an IA.
Okay.
If it's required.
Then don't say issue notice. Mr. S. Obadiah Leonard, counsel for the petitioner, also prays for 1 week time. 1 week time to file an IA for correction of the address of the respondents. Stop. Praise allowed. This is the matter after the winter vacation.
Deeply reversed, my lord.
6, six,
When the matter was called up on 24/5/2024, none appeared for the petition. Stop. On 4/11/2024, none appeared for the petition. Stop. Today, when the matter is called up for the petition, accordingly, this contempt petition is dismissed for non-presentation.
7,
In this case, my lord, we are going to file affidavit today, my lord.
Okay.
My lord, on the last occasion, they sought for an instruction whether the standing president is performing his duty or not.
My lord, we received the instruction, my lord. On the basis of that, my lord, we are going to file affidavit, my lord, today.
Okay, heard, Mr.
And Jaman.
Learned counsel for the petition. MSS Chutia, Learned Standing Council, Elementary Education Department submits that she has received instructions and prays for 1 week time.
Right.
1 week time to file affidavit. Praise allowed. List after the winter vacation.
8,
May it please your lordship. My lord, this matter has been listed for the first time, my lord. So, my lord, I pray for issuance of notice to.
What is your case?
And there is a direction of this honorable court directing the respondent, my lord, to take initiative for provincialization of the services of the teaching staff, my lord. And the order has been passed in February 17,
Oh, this is a contempt matter.
contempt matter.
When was the order passed?
Order, my lord, will find at page, my lord, 11. And the relevant portion, my lord, will find at page 13, my lord. There are 6, 7, and 8. Six, 7, and 8.
Okay, heard Mr. M.S. Chowdhury, Learned Senior Counsel, assisted by Mr.
P. Chakraborty.
P. Chakraborty, Learned Counsel for the petitioner, issue notice. Petitioner to take steps for service of notice on the sole respondent by registered procedure within 1 week, least after 6 weeks.
Hello.
11.
May I please your lordship?
Mm.
Lordship, matter may be on time being. My senior is in another port. Port number 9.
Father for the day, lordship.
Port 19.
Okay, let her senior come.
12.
In this case, my lord, last occasion, my lord, it was asked to get instruction with regard to my post, my lord. In the DLC, my lord, page 35. In 2006-7, my lord, against the page 36, serial number 10 was my name, my lord, in the DLC, my lord. There, my name was recommended against the existing post of 2006 and 7, my lord, at grade 4, page 36. And in 2006-7, my lord, one post was available for grade 4. And in the SLC, it is said, my lord, no post is available. So last occasion, that was, my lord, the learned court was supposed to get the, my lord, friend was supposed to get the instruction with regard to this post 2006-7, page 35, my lord. 2006-7, number of vacant post 4, available under compassionate ground was 1. Against this post, I was, my lord, page 2005, 35, my lord, year 2006-7. Against this post, my lord, my name was recommended at page 36, my lord. Recommended for the year 2006-7 for grade 4, my lord. Now in SLC, my lord, they have said that there is no post available, page 44, my lord. On the ground of lack of vacancy, my name was rejected at serial number F, my lord. Down below, page 44, down below.
Yes.
Following are rejected on the ground of lack of vacancy. Atul Bora, son of. So last occasion, my lord, it was directed. In fact, order is not reflected in the order, but it was directed. What happened to that post which was, my lord, I earmarked against my post?
Yes,
My-
I can.
My lord, page 36, that has not apparent that any specific post was there. The year-wise vacancy only shows in the page 36. And normally, my lord, DLC, they are asking 2 months and FLC 3 months. And taking a consideration, my lord, that is number 44, my lord, SLC found that there is no post in the district.
Come to page 35,
My lord,
the top chart.
my lord.
2006.
4 vacancies are there.
My lord.
One is for commissioner appointment. Already appointed Neil.
My lord.
Then
No, this is the status, my lord, in 2012 only. My lord. That SLC, my
oh,
lord,
2006-7, Saikia,
my lord.
the vacancy, there's still one vacancy.
My lord.
2006.
Against that vacancy, the petitioner's name was recommended.
Yes.
My lord.
Page
SLC
36.
said there's no vacancy. This
My-
court, I wanted to know
against that
what
person-
happened, where that vacancy go?
My lord, against that vacancy, my lord, that post was not particular post was allotted.
No, that is allotted, my lord.
No.
2006,
There is
7,
no-
2006,
No,
7.
that is
this-
year-wise vacancy only.
My lord, 2006, 7, my lord, vacancy position were 4, available for compassionate appointment was 1. Now your lordship may, my learned friend is probably not reading it properly. Page 36, my lord, serial number 10 in the right side, right hand column, extreme right, recommended for the year 2006, 7. Extreme right hand column. Yes. For 2006, 7 only, he was recommended against this particular post. So no other was recommended for under this column. So that was specifically only for me. The remark is clear, man. So that's why, my lord, last occasion.
The remark said that, my lord, recommendation for the year of 2006.
Six and 7.
And my
And
lord,
this post
SLC,
was-
they are sitting in 2016, my lord. Now we are in 2024, my lord. Then 2016 SLC think that post has, whatever vacant post is there, my lord, that has already filled up, my lord.
This court, the DLC recommended the petitioner for the 2006-7 vacancy, one post.
One post, my lord.
When the SLC said, it said there's no vacancy.
No vacancy.
Where did that vacancy go?
But that vacancy, my lord, they may be accommodated to other person, my lord.
Then how can you do that?
Other SLC also there, my lord.
How can you do that?
No, my lord, because my lord, DLC has not earmarked any specific post, my lord. They have said, my lord, 4 number of vacancy in the particular DLC, my lord. Next, second DLC also, they are sending that this 4 number post is vacant. My lord. Therefore, there is no any specific allotment of the post, my lord.
See, this DLC
My lord.
is concerned with which district?
This is Jorhat.
This is
Jorhat.
Yes. No other persons
This
were
is Jorhat.
recommended
It
for.
is in 2013, my lord, assessment in 2013, my lord.
Yes.
So we wanted to know
What happened to
to
this
get the instructions, what happened to this post to which the petitioner was recommended?
My lord, that instruction can be given by the concerned administrative department. my lord. Because my lord, post is with them only.
Is it?
No,
Huh,
no,
recommendation came from you.
The vacancy position and my lord, there
No,
is a
no,
member.
Saikia, see, the DLC Jorhat,
My lord.
when it considered the compassionate applications,
Right.
found that in the year 2006 and 7, there were 5 vacancies.
Right.
Four, no, 4 vacancies.
Yes.
4 vacancies.
Out of the 4, 1 is for compassionate appointment. And accordingly, petitioner was recommended for that one post
Right.
for the year 2006-7.
Right.
Correct?
Right.
When it was considered by the SLC, the SLC said there's no vacancy. Then where is that vacancy to which the petitioner was recommended? What happened to that vacancy?
My lord, that vacancy, that's my lord. Here problem is there is no any specification by the SLC that this post meant for the petitioner.
Then you file your affidavit.
They have merely recommended, my lord.
Or you get instructions, proper instructions.
My lord, will file affidavit. my
Okay, heard, Mr.
J. Pine.
lord.
J.
In this
Pai-
matter, notice also not issued, my lord.
Learned counsel for the petitioner, issue notice. MSS Tutorial Understanding Council. Elementary appears for 1, 3, and 5. 1 also.
We are not, no, I mean, this is what I said.
You are appearing for 1?
I am for 2 and 4, my lord.
How about 1?
1, my lord, there is no any specific, my lord. State of Assam represented by the secretary, my lord. That there should be a department secretary.
Payang, how can you do this? Commit this type of mistake?
This is, sorry, my lord, this is wrongly typed. Probably, this should have been Secretary Education Department.
Cancel the order. Mr. J. Payang, learned counsel for the petitioner. Press for filing an appropriate application for correction of the address of the respondent number 1. Press allowed. Please stop for 2 weeks.
13.
Always.
May I please, Your Lordship? This matter pertains to compassionate appointment, Lordship. Lordship, one similar matter is pending, Lordship. That is application number 5067/2024, Lordship. One similar matter is pending, Lordship. But can it be taken up along with that matter, Lordship? My matter is also Lordship, same, my Lord. 5067/2024, Lordship.
My lord, here, my lord, there is a difficulty. Initially, petitioner claimed that he has applied within the time. Subsequently, which is placed before the DLC, that has said it submitted in 2012. That is the difficulty.
Okay. We'll list it with that petition, then we'll consider the matter.
My lord, otherwise, my lord, the petitioner have to show in this particular matter, my lord, then when he has submitted.
Yeah. On request made by Mr.
D. William, my lord.
None council for the petition, list this matter along with WBC 5267 of 2024 up to the window vacation. I'm not issuing notice.
Madam.
14 and 15.
They have already issued a show cause. 15 days time was given, we've replied, but nothing has come yet. So I think it can be listed after vacation. That did come by the dead report.
No, what the other side? Let us hear from the other side. No, state level cost scrutiny committee.
They have issued the show cause notice. This was issued on 20th of November 2024.
Okay, Mr. R.B. Furkan, learned counsel for the petitioner submits that the state level cost scrutiny committee has issued a show cause notice to the petitioner on
20th of November.
2011-2024.
We filed a reply.
Giving 15 days time to
Yes.
file reply. Stop.
We have filed it on 15th.
Accordingly, the petitioner has also filed a reply.
On
However,
5th of December.
On 5th of December,
Great.
2024. However, till date,
There's no response from them yet.
however, till date, there's no response from the said state level cost scrutiny committee. Stop. Recording the submission made by the learned counsel for the petitioner, list this matter after the winter vacation.
I think they'll need some time. It's to
Let
come
it
out.
come.
And
Nobody is representing them. Otherwise,
first of
on their request, we could have given them some time.
Fair.
Let it come after winter vacation. On that day, if they want time, we'll give them time.
Okay. What would your lordship be giving a date? Or
I'm not giving
Okay,
a date.
no problem.
Any interim? Is there no interim?
There is an interim.
In
And-
which writ petition?
This is the second one.
Interim order passed in WBC 4440 of
4440, 2024.
2024 to continue till the next meeting.
Great.
16. Sixteen.
None appears for petitioner. List up to winter petition.
17 and 18.
May I please? In this case, my lord, impugn order is that page 54, my lord.
Page
54. During the pendency of the earlier writ petition, my lord, item number 18, my lord, they have issued the impugn order, page 54. And in earlier writ petition, the status quo is there. But in the meantime, what happened, my lord? They have modified the order in respect of the private respondent. He has been reposted somewhere else. And but this second part of the order has not been modified. Though I'm continuing in the same place of posting. He has been posted somewhere else. I've been hired.
Yes, Chuti.
এটা মানে এটু হৈ গল এটু বেলেগ পোস্টিং পাই দিতে নংকা না হয় একবার দিতে আমার তো জানি So my lord, it notice may be issued, my lord, and status quo is there in item number 18, but that may continue, my lord.
But Mr.
Hello, item number 18. I applied for the response number 5.
Okay, 1 minute.
The
Item 18 notice is gone.
Yes, yes, notice is gone, my lord. Private respondent has appeared, my lord. Status quo is there, my lord.
and already all the orders are modified. I was posted at Chenga, but where Sumim Bashan, the restaurant number 4, was transferred from Barbata to Chenga, he was again transferred to Borigal, another place. And one Leonardo Das was reposted at Barbata. He is in his post, my lord. Yes. 18 I am restaurant number 5, 17 I am not there.
Then item 18, does it survive?
Yes. Both the, my lord, here this notice is not issued, my lord. Item 17 notice is not issued.
No, how about 18?
18, they have appeared, my lord.
The orders are already modified.
Already modified, my lord. All have been placed. I'm also continuing my original place, but my order is put to, my lord, they have intended to modify, my lord, to impugn order in item 17. And so far as the, my lord, my lord, private respondent of item number 17 is concerned, I've been heard that he has also been given the place of posting somewhere else. But my place of posting with regard to, my lord, that has not been modified. That's why.
But Mr. In item number 17, be forecasted in the concept of issue.
Item 7 is our category.
Issue notice. MS S. Chutia, Learners Council, Learners Standing Council, Elementary Education Affairs Correspondence 1, 2, and 3. You are appearing for
No, 17 I am not aware.
Okay.
My lord, for respondent number 4, at this stage, he is not required to be issued notice because he has got the place of posting somewhere else.
We'll issue notice to him, let him come.
Let him come also.
Extra copies of this petition for so. Petitioner to take steps for service of notice on the respond number 4 by registered proceeding within 1 week. List after 4 weeks. Interim order passed in WBC number, not interim, status quo order passed in WBC number 1480/2024 to continue till the next September.
19.
Oh.
Your Lordship, has heard this matter. Madam.
Lordship, in this case, as per instruction, Lordship, Block Elementary Education Officer Goreswar forwarded a letter regarding resolution taken by School Management Committee for upgradation of Arun Kumar Das and Vipul Chandra Das. Didn't DU Baksa had letter dated forward a report of Deopusi Adarsa ME School to Director of Elementary Education Assam Kailipara, Guwahati 19, Lordship. So, Lordship, it is up to the government of Assam to decide the matter, Lord. We have forwarded it to Assam government.
My prayer is that let respondent to issue an order accordingly, madam.
Okay. Then we issue notice at this stage.
No, but your Lordship may close the matter, madam, because already they have done the process. The only thing is that they have to issue an order according to rules. According to law.
So you want that order to be passed?
Order to be passed, madam. Let them pass an order, madam.
Yes.
Order to.
Huh? Or you take instructions and come back instead of issue. Give me your instructions.
Lordship, I could not send in mail. Lordship.
Okay, heard Mr. D.K. Das.
Your Lordship has already on 3 occasions has already passed
assisted
an
by
order.
MS
The other
J. Acharji, Learned Counsel for the petitioner. MS R.B. Bora, Learned Standing Counsel BTC. On instructions, submits that the which authority?
DEO Baksa.
That the District Elementary Education Officer.
Baksha.
Baksha.
Dada.
That the BEO, not Not
D-
DU.
District Elementary Education.
DU.
District Elementary.
Okay, on instruction submits that the BEEO, comma, Goriswar by a letter dated 6/7/2018 has forwarded the resolution taken by the school management committee for upgradation of the petitioners, and the then DEO Baksha has also forwarded a report of the what is called Duilkuchi Atarsha ME School to the Director of Elementary Education Assam for necessary action. Stop. But
My- over paper 35. I thought that it was actually over paper something. It's not.
No, wait, Muri. Hey, Muri,
no, here it is written as Director of Elementary Education Assam. Okay, MS S. Chutia, London Standing Council, Elementary Education Department shall take instructions. Shall take shall take further instructions in the matter. Stop. List the matter after the winter vacation.
Let a date be fixed, my lord.
That will be difficult after the winter vacation. It's all jumbled up. You can make a mention if it's you're in a hurry after the winter vacation.
তেতিয়াই তোমাৰ মানে হেৰি কৰিম।
কৌশিক, কৌশিক আছে।
Yes, Beku,
My lord, I have
what
noticed.
is taking the director so long to dispose of one representation?
Yes. That instruction is not with me, my lord.
See, when did you retire?
My lord.
When did you retire?
Petitioner retired in the 1999.
1999, 1999.
My lord, kindly fix short date, my lord, I'll take it.
Okay. First week of January, madam.
Pension tax.
Mr.
Regarding refixation, my lord, may issue
He has
notice.
get the pension, man. He has get the pension, madam.
Are you getting pension?
DPU has already issued.
My lord, but not in an enhanced rate, my lord.
Not in the enhanced rate of the headmaster.
Yes, madam.
Madam, therefore, we are saying, madam, notice may be issued.
Okay, then notice will go.
Right,
Heard, Mr.
DCC Pukan.
DCC Bukan and the Council for Petitioner issue notice. Mr. G. Bekul and the Standing Council Elementary Education Department address 1, 2,
1, 2, 4. Oh, no.
1 and 2.
5, my lord, I may.
How about this?
4 also, I am. 1, 2, and 4, man.
Darang?
Darang.
1, 2, and 4, huh? BTC? Mr. P. Nayak, Learner Standing Council, BTC, appears to respond number 3. And Mr. P. Cycle and Governor Advocate appears for the response number 5. Notice and responses are complete. However, extra copies. Respondents are allowed to file affidavit list after 2 weeks. After 2 weeks. Or 3 weeks, I'll give it a list of after.
21.
Who is there?
We'll take up this matter.
Okay, it's trending down to the PTC.
Yes.
May I please, ma'am? Lordship, we have challenged the selection of respondent number 5, Lordship, for the post of assistant teacher Hindi post, Lordship, in BTC area. Lordship, pursuant to the advertisement dated, Lordship,
Where's the
that is page
advertisement?
17, Lordship. Page 17.
Yes.
Pursuant to that advertisement, Lordship, we have applied for the post of assistant teacher in upper primary against Hindi post, Lordship.
Okay.
And pursuant to the advertisement, Lordship, a verification list was published, Lordship, that may be seen, page 33. Page 33, serial number 377. This is the petitioner, Lord. 377, right hand side, Lordship, 20.65, petitioner is scored.
Oh.
Page 33.
Oh.
From bottom, Lordship, 377 serial number.
Okay.
Shahana's Lordship, she got 20.65.
Hmm.
While Lordship, now kindly see next page, Lordship, in serial number 2490. Next page, Lordship, page 34. Bimala Devi, respondent number 5, she got 18.32, Lord.
Is the respondent number
5. Private respondent number 5. This is our case, Lordship.
Yes, Nayak.
Some other similar matters are also there, Lordship. Lordship may issue notice at this stage.
Whether any appointment notice have been issued?
That instruction I have to take. Which one could I select? Which one could I P44. There is the memory. Appointment. Not will take up this matter immediately after vacation, not upon 3rd or 4th, 5th, not 6th. Not. In the meantime, I will have some answer.
Okay, heard, Mr.
Eti Sharkar.
Learned counsel for the petitioner. Stop. Pursuant to an advertisement dated 17 January 2024. Issued by the
Director of Education PTC.
Issued by the Director of Education.
Page 23. Director of Education, BTC Kolkata.
Director of Education, BTC Kokrachar. For filling of vacancies of assistant teacher, science teacher, and Hindi teacher of UP schools. The petitioner applied for the post of
assistant teacher against Hindi post.
Assistant teacher. No, for the post of Hindi teacher.
Hindi teacher.
Of the upper primary schools. Stop. Thereafter, comma, the respondents issued a select list when was the select list issued?
Lordship, that is page 45, date is not mentioned, Lordship, it is downloaded copy, 21/8/24, Lordship. That is 21/8/24, page 35.
Where?
Lordship, date not mentioned, Lordship, in the, Lordship, we have mentioned in our paragraph, Lordship, that was published on 21/8/24.
on 21/8,
20.
2024. Stop. During the name of the petitioner appears at serial number.
Lordship, this is a selection list. Earlier one is verification list, Lord. That was merit list, Lordship. Pursuant to the verification list, Lordship, this list has been published, Lord. 21/8. And verification list, Lordship, that is page 26, Lordship. Merit list, Lordship.
No, this is not a merit list.
Verification, Lordship, page 26 may be seen.
Oh, this is a verification list.
Verification list. Lordship. In
Ah.
the verification list, Lordship, my mark was shown. Serial number. It's, more than the petitioner, Lord.
Where is your verification list?
Page 33, Lord.
Oh, that's fine. And where's the, after the advertisement, after the verification list?
Yes, Lordship, this
Then,
one verification list, page
after
33.
that, there's a recruitment process.
There are recruitment process, and in the recruitment process, Lordship, finally, select list has been published.
Where's the select list?
Page 35.
Huh?
Page 35. Page annexer 4. 8 persons have been selected, Lordship, against Hindi port.
Huh?
This one is we have challenged, Lord.
Serial number 8 is the private respondent.
Yes,
Fine.
He's
But
challenging.
there's a selection process, isn't there?
Yes, Lord.
Yes.
This, the first one is the verification list only.
Yes, yes, Lord.
It's titled List of Candidates who applied for the post of assistant teacher of UP schools under BTC area.
Yeah.
Last column, Lordship, average obtained is there.
Oh.
And it is his allegation that he obtained more marks than the private respondent.
In that verification list.
Yes, Lord.
How about after the recruitment?
Yes, Lord.
Thereafter, Lordship, this selection list has been published.
Okay, what is that? Applied for the post of students, huh? After, comma. The Director of Education, BTC Kokrachar, issued a list of candidates who had applied for the post of assistant teacher of UP schools under BTC area on 28/6/2024. Stop. In the set list, the name of the petitioner appears at serial number 377 with an average mark of 20.65. Stop. The respondent number 5 appears at serial number 2490 with an average mark of 18.32. Stop. The petitioner is aggrieved by the list of selected candidates of UP assistant teacher arts within bracket Hindi in order of merit, by which the respondent number 5, by which the name of the respondent number 5 appears at serial number 8. Stop. But I'll issue notice then. Issue notice. Stop. MSS Tutel and its Standing Council Elementary Education appears for serial number 1, 2.
1 and 2
One and
1 and 2, Mr. P. Nayak, London Standing Council, BTC.
3 and
appears
4.
for 3 and 4. Extra copies. The petitioner takes steps for service of notice on respondent number 5 by registered post AD within 1 week. This after 4 weeks.
1.
Public.
In time na lage?
My lord, I have checked. I have, my lord, down given the entire select list. The applicants, my lord, their name does not figure in the select list. The select list, my lord, in which, my lord, I am figuring, which is annexed, my lord, as annexed page 38 in the entire select list, my
Where's
lord.
the select list?
Yes, my lord. Your lordship will see, my lord, the admission notice makes it clear, page 36. There are total, my lord, 1577, my lord, candidates who figure in the select list, page 36, my lord. That table your lordship will find. And in the entire select list, my lord, the applicant's name does not figure. I have given, my lord, in the online to the, my lord.
Select list.
Page 36, your lordship will see, my lord, all these persons who have figured, my lord, up to 1577 in a table, your lordship will see, page 36. They are called. My lord, the position of the petitioner is 574. So she was called on 29. Now this is, my lord, the select list, which is annexed at page 38, part of the select list. And in the entire select list, which I have given, my lord, their applicant's name does not figure. So therefore, their rights crystallizing, my lord, at this stage, my lord, does not come into play. And my lord, my learned friend will submit whatever, my lord, for the central government.
Where's Saikia?
That part we have no rule. One query was put by my brother has says that losses has to wanted to know when that particular uploaded loss. In respect of lordship, may after some time I will obtain instruction because the concerned person of that lordship, National Board of Examiners, he is in the premises of the Honorable Delhi High Court lordship, one matter is going on. He will provide the document lordship may after some time. Regarding
Okay,
that
see,
particular-
Gogoi, the issue is there's some urgencies involved in this matter.
Today itself, lordship, I will try before one, otherwise at two, I will place in the instruction.
Okay.
When it was uploaded, but regarding other part, we have no rule.
What do you call that, what bulletin was it?
That 2024 bulletin, and as per the telephone instruction, my officers, lordship, they says that, lordship, other.
Information bulletin.
After that, another one is lordship issue. They've informed me, lordship. Both the documents they will send me, lordship. 2024 information bulletin, lordship. After that also another document was issue uploaded, lordship, as because
Do you have a copy of the writ petition?
lordship, I have second copy I have taken.
You have not furnished. a
They have
copy?
furnished one copy of our office, lordship. I have the copy. Only I will furnish the instruction when the particular document was uploaded in the website, lordship.
You also take instructions with regard to page 29.
Lordship. Lordship.
Okay.
In respect of 29, lordship.
No, yes, 29. According to the state respondents,
Lordship.
they are saying this is just tentative.
Lordship.
This is only a tentative notice.
Tentative, lordship, whether it's a tentative or not, lord.
And according to the petitioner, it is this date that it has to be reckoned. And if it is reckoned from this date, then that amendment of 2013 will not come into play. Insofar as this selection is. That's all. Because I have to give an order, I have to pass an order.
Otherwise, lordship, that part, lordship, in the short notice, lordship, I will try my level best, lordship.
Okay.
I will try my in the short notice, lordship, because the office is in the Delhi, lordship. I am here, lordship, and telephoning. I will try my best, lordship. Otherwise,
No,
lordship,
don't get telephonic instructions. Try to get some short written instruction, whatever it is. If necessary, we can take up this matter tomorrow morning.
Lordship.
If necessary.
Lordship.
But then, see, there's no time for the
Lordship,
petitioner.
lordship.
Supposing I go against the petitioner, he'll have, the petitioner has to file an appeal.
Yes, correct, my lord.
Before anything.
It's a tentative schedule or it's a final schedule, lordship, may I have to obtain instruction?
Yeah, well, no, it says it is tentative here.
Lordship.
But according to the petitioner, the process of recruitment or selection started from this date. And they are relying on a Supreme Court full bench, constitutional bench decision to say that it is from this date that the selection process will be reckoned. And therefore, if it is 9/11/2023, then the 2013
23 amendment, lordship.
The March amendment, March amendment will have no effect. And the earlier rules will apply. Okay.
My lord, I submitted additionally that pursuant to this notice, subsequent notices were issued. But those are complementary, man.
By refixing the date.
Yes, refixing the date. And this notice has to be reckoned.
But according to the respondents, this information bulletin is the date which,
Yes, there, that is their submission.
according to that.
Yes. And my lord, my learned senior friend is there. I was submitting that their name does not figure in the provisional list. Mr. Saikia is present, man.
You have a copy of the affidavit opposition filed by the
No, Lord.
medical department.
I
Give him a copy. There they have annexed one information bulletin. They are saying it is this information bulletin from this thing, it will have to be considered. Okay. If you have some problem, you can inform me. You can inform this court.
I'll try, Lord. Sir.
We can adjourn it. Let us up to tomorrow morning.
Lord, sir, I'll try, Lord. I'll try. Oblige.
At 2 p.m., my lord.
No. He has given a select list,
This is the select list, my lord.
provisional select list.
Yes. Yes. Provincial select list is 26/11/24. On where I have secured this seat, my lord, at serial number 401.
Anyway, that will consider later.
Yes, sir.
We take up at 2 o'clock.
2 o'clock.
Twenty-three.
City Lordship, as per Lordship station, I have received instruction, Lordship. Here, Lordship, one thing I stand corrected, it's a engineering college, Lordship. There, Lordship, some misconception is there. It's a engineering college. Otherwise, I have received instruction, Lordship. Detailed instruction, the reason behind this, Lordship.
This one.
Lordship. Basic purpose to release the petitioner is that for implementation of the Lordship cabinet deal. That is the basic reason, Lordship. Otherwise, if he has a grievance, Lordship, violation of the contract, Lordship, he can avail the appropriate remedy, Lordship, for violation of the contract. Otherwise, we go by the Lordship as an employer, our duty is to fulfill the Lordship, all the requirement, Lordship, which was given by the due approval of the cabinet, Lordship. This is the basic purpose for release the petitioners and all other similarly situated persons. It is the basic reason, sir.
So petitioner's post was not advertised.
It is not advertised, but Lordship, for not only petitioners, several posts was not advertised, but we have to accommodate the persons under 3F category. So all have to release those. The persons who are in the contractual or a Lordship part-time lecturer or a guest lecturer, all have to release those.
What is the position of the petitioner?
They have to release those. They have told you after if they fulfill all the criteria, then it should be considered under TF regulation. TF. That is the purpose. And he says that the by violation of the contract, it's a lordship, if violation of the contract, then he can avail the civil remedy for violation of the contract. Otherwise, as the employer, our duty to treat equally so everything. And earlier one also approached before lordship that Barfatto Guha is senior advocate. Same, his post was also same institute. Lord. And if lordship permit to file our affidavit, we can put it away by way of affidavit also. Lordship.
Okay.
Otherwise, lordship, we all have to go, lordship.
Yes. Yeah, my lord, what happened, my lord? The cabinet has decided, my lord. In this regard, my lord, I have filed an additional affidavit, my lord. In additional affidavit, my lord, after the cabinet decision, my lord, lordship will find at page 46, my lord, annexus 17, my lord. This has been submitted by the director, my lord, DTE. Yes. And next page 47, my lord. The part-time faculty of engineering college engaged in the institution under DTE Assam. My lord, serial number 6, my lord, in the table 24, my lord. This is the total part-time employees working in the institute, my lord. And my lord, this has been submitted, my lord. And thereafter, what happened, my lord, everything has been submitted before the government, my lord. As per the cabinet decision, my lord, 351, my lord. These are the 351, my lord. These were the persons. And everything, my lord, the requirement of the budget for payment of the remuneration to the part-time faculty and part-time senior instructor engaged in the institution of Directorate of Technical Education, Assam, my lord. That is at page 51, my lord. And thereafter, my lord, turn to page 52, annexure 18. That is very important, my lord. This has been issued on 8th November 2024, my lord. Latest, my lord, after filing this case, my lord. Director of Technical Education, the additional secretary has issued this letter. With a reference to the subject cited above, I am directed to convey the approval of the government in higher education technical department to propose engagement of the retired professor to teach the subject of the BTech in engineering and BSc in science and information technology. This is my post, my lord. Program as the communicated by your letter under reference. And after getting that, my lord, the director has issued a letter on 30/11/2024, my lord, latest letter, my lord, to the all principals of all government engineering college. And this is the subject with that. With reference to the subject cited above, I am to forward here with the government approval letter regarding the engagement of the retired professor, my lord. Retired professor against my post, my lord. I am holding the post after execution of the agreement, my lord. In the agreement, there are clause 5. It was clearly stated. Kindly give a look, my lord, for the time being, my lord. That is available. That is at annexure 10, page 27, my lord. Clause 5, my lord. Clause 5. The engagement as guest part-time assistant professor in engineering college or guest part-time lecturer in polytechnics may be terminated at any time without any prior notice and assigning any reason thereto. In case performance of the guest part-time assistant professor in engineering college lecturer in polytechnics is found unsatisfactory or regular faculty is appointed against the
Gogoi, what is this? The engagement of retired professors?
Kindly peruse the subject.
What subject?
Page 52, lordship. External teachers. It's for external teachers. Regarding engagement of external teachers on online, offline mode, lordship. Conduct newly incorporated courses under NEP 2020, lordship. It's under the National Education Policy 2020.
But by letter 30,
How about page 53?
Same on the basis of that letter loss, government that letter loss. 8 November 2000.
Now, what is this external teachers?
External teacher, some lordship, external aid is required in the some subject lordship. Specialist teacher is required lordship. That's why that proposal was given.
Not affecting the petition.
Lordship, petitioner, their posts are not affecting. Those who are contractual and guest and part-time. First of all, they have to lordship go. After that, we are converting them under the TF as per the cabinet proposal law. That is the issue, lordship.
Okay.
This way, that way, they have to go, lordship. This way, that way, they have to go for the purpose of implementing the honorable cabinet decision.
Okay.
Otherwise, if lordship directed us, I can put it by our affidavit, everything, lordship.
Let it come by way of notice.
Lordship,
My
lordship.
lord, one thing, my lord, kindly give a look, my lord, for the time being, my lord. One letter, my lord, by which letter, my lord, we are going to be terminated, lordship will find at page 32 and Annexure 12, my lord.
Now,
Yeah, last paragraph, my lord. Moreover, you are also requested to ensure that the service of the part-time faculties in engineering colleges, polytechnics under the government of Assam, which the Honorable Guwahati High Court has ordered not to disturb, should not be disturbed, my lord.
That's why.
Similar situated person,
That's
my
why
lord.
yesterday's.
One of this.
That's why yesterday's lead petition.
One thing, my lord, here, my lord, in the list, my lord, one another verification list has been prepared by the college as per the direction of the director, my lord. That is at page 6, my lord, page 23, Annexure 6, my lord. This verification has been done by the college whether the person's part-time faculties are eligible to hold the post or not, as per the guidelines of the UGC and AICTE. And there, my lord, lordship, my name will find, my name is at serial number 9.
okay.
And 10 is the Dr. Navakrishna Bora. He's also eligible, my lord. He is working, my lord. He will not be disturbed, my lord. Because he is getting a lordship's protection, my lord.
But these are those who came earlier, not now.
That person
My lord,
also.
yeah, my lord, what happened, my lord? They are going to make us the TF, and the proposal has been submitted by the DT before the government with the budget proposal. In the meantime, my lord, what happened, my lord, till the date of the new appointment under the PA proposal, and I have been already executed the agreement with the college department, and it is clearly stated that till the new man has not been come as per the regular employee, my service will not be disturbed. And there is no any adverse remark against me, my lord. I have enacted my character certificate.
How long is the process going to take?
My lord, I may be allowed to continue.
Sometime
My lord.
otherwise, Lucy, that proposal also very specific. The appointee of the director, Lord. Part-time and contractual appointee of the director, Lord. They are converted. The principal's appointee is not there.
Correct.
Even, Lucy, in this case, there is no appointment letter as per the instruction, Lucy.
My lord,
As per the instruction, there is no appointment
Okay,
letter.
heard, Mr.
Either this way, that way, they have to go, Lucy.
D. Bora, Learned Counsel
Borua,
for the
Lucy.
petitioner. D. Barua, Learned Counsel for the petitioner. Mr. K. Gogoi, Learned Standing Counsel Higher Education, submits that he has received instructions and prays for a short time to file affidavit. Praise allowed. When 3rd, release the matter on 3rd January.
Till then, my lord, my service may be protected, my lord.
Oh, I don't think that.
My lord, I may be otherwise, my lord, I am still working as per
If
the
he is
English
entitled, then he will get any time, Lucy.
You don't have an appointment order as per this instance.
No, my lord, what happened, my lord? My lord, in this regard, my lord, I have a small pair, my lord. Kindly
Yes.
give a look, my lord, in my petition, my lord. One thing is that, my lord. One thing is that, my lord. One thing is that, my lord. That is very important, my lord. I have been terminated on 16/7/2024, and thereafter, my lord, the Director of Technical Education directed the principal, kindly page 26, Annexure 9. Further, it is also informed that in the interest of the uninterrupted academic activities, the guest part-time faculties who were otherwise eligible for engagement as per AICTE norm at GIST Juhat may be re-engaged with a break in service after having executed proper memorandum of agreement MOA. Copy of the draft MOA will be provided in due course of time by the part-time faculty with the engaging authority as per the government letter under the reference to above copy and group. And that government letter Lordship will find at page 24, my lord, annexure 7. With reference to the subject cited above, I am directed to inform that the government of Assam in higher
Lordship, all
education
the
technical.
exercise prior to the cabinet decision, Lordship. All the exercise prior to the cabinet decision.
Okay.
Now we go by Lordship date.
Let it come on third
Lordship.
Lordship, 3rd of
January.
January.
Yeah, on the opening day, because you require some. This thing.
Oblige, Lordship.
24, 25.
May I please? But in item number 25, my lord, already reading is complete, my lord. And in that case.
Why is it listed with this?
My lord, yes, it's a new case, my lord. In that case, my lord, they have next one of letter, my lord. If you here, page 51, my lord. On that NF this, my lord, letter and stating
Page
50. Annexure 10.
period of 22nd February 2022. And on the basis of that, they have stated that for issue is with regard to holding of the charge of the principal, newly upgraded higher secondary school, principal of the newly upgraded higher secondary school, my lord. And they have stated for this, they are not in a position to give me the charge. They are given the charge to the headmaster. Inspector of schools, my lord. But this letter itself, my lord, says clearly, last paragraph. Secondly, as an interim arrangement till the post of headmaster.
Page 51.
Yes, lordship.
Page 51 is it 2/2/2023?
2022.
22nd February 2022.
No, my page 51 is.
Lost to be a second of 6550/2024.
WBC 6550.
Okay. Okay.
I will also find the last paragraph. Secondly, as an interim arrangement till the post of headmaster is upgraded to the post of principal and till regular principals are appointed, the existing headmaster of these 218 numbers of schools may be allowed to officiate as in charge principal, provided they have the requisite academic qualification, master degree in arts, science, commerce with B.Ed degree, and in case of present headmaster does not have MA, MSc, MCom / B.Ed degree and B.Ed degree, the next senior most teacher of the school with requisite qualification of MA, MSc, MCom and B.Ed degree shall be allowed to hold the charge of in-charge principal with approval of the government till regular principal is appointed. Therefore, my lord, as regards my lord, the requirement of 17 years of teaching experience as graduate teacher in a provincial school, that has been relaxed. Only the preference has been given to the qualification. The senior most teacher of the school having these qualifications will be given the charge of the principal. The school.
Is there a relaxation clause in that act?
Yes, rule is there, my lord.
Is there a relaxation clause?
Yes, the rule is there.
There's a relaxation clause.
Now, so far as this letter is concerned, I have to take instruction whether it is still in Lordship, whether we are following it or not.
They have next in the connected read petition in the
I have to
opposition.
take a specific instruction regarding it. Lordship. So it just came from notion.
Apart from
notice.
Apart from that, my lord, another thing is I'm pointing out, my lord. In the Assam higher secondary schools are regulated by one act, my lord, called Assam Higher Secondary Education Act 1984. And on the basis of that act, my lord, there is regulation. 1989 regulation is there for which regulates the, my lord, mode of granting recognition, etc. of the higher secondary schools. As per that recognition clause 7, page 48, my lord, which says, which also prescribes the qualification to be the principal. And according to that, my lord, 10 years experience, if someone has got the 10 years teaching experience, my lord, 35 years of age and master degree and B.Ed, he can become the principal. This is also there. This is also there.
But Mr. P. Purkastel and counsel for the petition. Can that affidavit cover this affidavit?
That was filed in the subsequent case. Let me take instruction, specific instruction regarding this annexure law.
I'll give you a short time only.
Yes. Anyway, this is of 2022. Now we are challenged it in 2024.
Fine.
Let come after vacation law.
No, I'm fixing a date.
Yes.
Issue notice.
And inspector is still
Mr.
now holding the charge.
Still and standing counsel, secondary education appears on behalf of all the
Yes, all
respondents.
the response.
Notice and responses are complete, however, extra copies, respondents are allowed to file affidavit. This matters again on 20 January.
20.
Oh,
Oblige.
11.
don't say again, list this matters on.
This matter, in this matter, Lordship, by the order dated 29/8, respondent was directed to file the affidavit, Lordship. So, and probably it has to be posted in admission column, Lordship.
Notice has gone or not?
Notice has gone, Lordship. He has entered appearance.
No, notice.
The
Notice is notice.
implement petition by the BTC has been implemented as the necessary party here. And BTC has already entered appearance, Lordship, as Bora.
Notice has not gone. We'll issue notice. BTC has been impleted, isn't it?
Yes, Lordship.
As respondent 5.
Yes.
Have you filed your amended cost title?
Yes, Lordship, that is the.
But MST song and a council for the issue. Issue notice. Elementary, Mr. P.K. Boral and the Standing Council Elementary Education appears for the respondents. 1 and 2. Udalguri is BTC or
BTC. I am for 1, my lord, and 2, Director Elementary.
Nayak. Deputy Inspector, District Elementary Director.
11.
Appears for the respondent, standing all BTC appears for 3, 4, and 5. Notice on respondents are complete. You have given extra copies?
Yes, allocate. Also,
Okay. Extra copies. Respondents are allowed to send up. How much time you require? List after?
Lordship,
At the end of the-
end of the January.
Okay.
Peak date be there.
After for 4 weeks. Did it come out?
Let a date be there, Lordship, otherwise difficult to.
Okay, list the matter on 29 January.
I'm deeply obliged.
26.
May it please the lordship. My lord, the petitioner before lordship is 61 years old, my lord, lady, my lord. And my lord, the matter pertaining to family pension, my lord, husband expired. And dispute was arisen between two co-sisters, my lord. Earlier, the writ petition was disposed of, my lord, directing both the parties, my lord, to equal the share, my lord. Now, my lord, the co-sister is not coming to the office and not supplying any document. Now, the petitioner before lordship is old aging person and, my lord, having some financial problem. Some communication letter was issued by the authorities, my lord. Lordship may kindly examine, my lord. Page number 40. My lord, page number 48. Relevant part, my lord, page number 49 down below, my lord. The order, my lord. There are 5.
48.
Page number 48, my lord. Page number 49, relevant part, my lord. Page number 49 down below, para number 5. This was the order of the earlier writ petition, my lord. Accordingly, the writ petition is disposed of by directing the respondent authorities to pass appropriate order for grant of pension in favor of both the petitioners and the private respondent number 5 in equal share So, my lord, there
After this, what happened?
after this, my lord, lordship, page number 53, my lord. Page number 53, this letter was issued by the director to the secretary to the Government of Assam, my lord, regarding the pensionary benefit of the petitioner, my lord. My lord, after passing of this, issuing of this letter, my lord, another two letters, lordship may kindly see just page number 54 and 55 regarding similar issue, my lord, the family pension of the petitioner. Only problem is that the post sister is not coming to the office, my lord, of the pension to take the pension of 50% of her share, my lord. But our problem is that lordship may direct the authorities to issue pension, my lord, to me 50% my share, my lord. That much limited prayer. Lordship may dispose of the matter, my lord.
Yes,
Order is
Okay.
already there. Only our part I am praying, my lord.
Look at page 55.
My lord, page 55 is a letter, my lord, issued by the director to the issued by the director pension to the treasury officer, my lord.
See,
Therefore,
they are not in a position to give the pension.
pension because, my lord, the co-sisters, my lord, is not coming, my lord. Entire records is with her.
Sakya, you are appearing in this matter?
Page number 55, my lord, it has issued to the treasury officer.
What you do is you get some instructions and come back. Otherwise, petitioner is suffering. We'll list it on the opening day and then. The only problem is the petitioner is ready to take the 50%. 50% will go to the co-sister. But the other side is not cooperating, not coming. So what the petitioner wants is, I want my 50%. If the other one does not want to, that's up to the petition and the respondent. You get some instruction because from a rating of this 55, I don't think you have finalized the pension.
The pension has finalized, PPO had issued.
Then it has been returned back. So there's something there.
Otherwise, my lord, this private respondent also party here. My lord, may issue notice. In the meantime, we will also obtain inspector. If she is appearing here, my lord, everything will be clear.
If he comes here also, maybe we can sort out the matter here.
The petitioner can.
My lord, actually, so far the earlier, this honorable court's order, my lord, she has also no objection. 50% is already provided to her, but she is not willing, my lord. If lordship desires, my lordship may dispose of, directing the authority to consider my grievance, my lord. That must matter.
No, but then if the other side is not cooperating, maybe they'll be having some
Other side.
impediments.
My lord.
So I think we issue notice, let the other side come.
My lord.
Heard, Mr.
A. Ali.
Then we call for the petitioner, issue notice. Elementary, MSS duty and understanding also elementary. Appears for respondents, one and two.
I am for
And
three,
this
ma'am.
Sakya, Leonard, government advocate, appears for respond number 3. And MS and A. Sharma, Leonard, counsel appearing on behalf of P. Chakrabarty, Leonard, standing counsel, accountant general for the respond number 4. Extra copies. Petitioner to take steps for service of notice on the respond number 5 by registered OCD within 1 week. If you want to expedite the matter, I can give you Dusty also.
Dusty, my lord, Dusty.
But additionally, petitioner is also permitted to cause service of notice on the respond number 5 by Dusty service to the registry of this court within a period of 1 week.
1 week, my lord.
1 week from today. Drafter petitioner shall file an affidavit to that effect. Stop. We'll give a short notice.
My lord. There may not be a bar, my lord, during dependency, my lord.
Mr. Matter after 4 weeks. Pendency of this writ petition shall not be a bar on the part of the respondents to consider the case of the.
My lord.
Okay, vote.
Complaint.
Thank you. Appeal is dismissed.
Medical method. As per Milo's direction, I have got a specific instruction of it. Regarding that notification was noted page 29. It is a purely tentative lossy, page 29 lossy. Annex 6 lossy.
Okay.
Purely tentative and other parts losses has directed us of the instruction regarding lossy date of notification lossy.
1 minute. Okay.
Regarding date of notification, that information goes out lossy.
Which one?
Page
Annex A, page 61.
Page 61 lossy. Page 60. Additional lossy, no? Page 61 lossy. That is lossy when 16th of April 2024 lossy. I have the notice lossy. That I can do. Regarding examination schedule also lossy, I have the notice lossy. It will be conducted from 11th August. It was already conducted 11 August 2024.
1 minute. 16/4/2024.
2024. 16. Melon May 4 lossy, CL number 4.
Oh, this is not the information bulletin. This is a notice.
Lordship, this is notice regarding publication of information bulletin, Lordship.
Huh?
On 16/4, Lordship. My Lord, may kindly here, click here the information bulletin need PG 2024.
Okay.
Lordship, this is 16/4, Lordship. And regarding examination part, Lordship, it is the Lordship eligibility is cut off there up to 15 August, Lordship.
Where?
This is the document, Lordship.
That is the next ballot in the writ petition, page 31.
And this information was provided by the Lordship Deputy Director of National Board of Examination Medical Science. Lord. Regarding publication of information voucher, Lordship, there is no dispute. It is 16 August, Lordship, 16 April, Lordship.
Information bulletin.
16 April 2024. Lordship. That part 3 is there, Lordship. That portion is there. 3 and 4, Lordship. 4, Lordship.
Okay.
Lordship.
My Lord, I may give a short reply to this. My Lord, so far as the date of examination is concerned, my Lord, there is no dispute. I am not saying that my Lord, page 29 my lord, it gives a final schedule. That is nobody's case. And so far as the information bulletin is concerned, my lord, being relied on by the respondents, my lord, that bulletin also, my lord, gives a tentative date. Date is 23rd June 24, page 62. That date is also tentative because eventually on this day, examination was not held. 11/8 examination was held. Now the question is, my lord, whether or not this particular document at 29 has initiated, my lord, this election. That is the question. And my lord, this document has not been disputed. National board does not say that this document was not, my lord, issued by them. My lord, to reiterate, my lord, again, read, my lord, para 13 of the judgment. The process of recruitment begins with the issuance of advertisement and ends with the filling up of notified vacancies. It consists of various steps like inviting applications, scrutiny of applications, rejection of defective applications, or elimination of ineligible candidates, conducting examinations, calling for interview or viva voce, and preparation of list of successful candidates for appointment. Now, my lord, the submission of the application is a part of the process. In my respectful submission, my lord, that will not give rise to any fresh cause of action, man.
That part is.
Yes. And secondly, my lord, so far as the implement is concerned, my lord, I have checked up from the select list. 3 candidates does not, there are total 4 applicants. 3 does not, my lord, appear in the select list. Their name does not figure. 1 candidate, Indranil Sharma, his name appears in the select list. By this time, he has already got the admission. He has got the admission. So in respect of 3 others, my lord, their name does not, my lord, figure in the select list. So therefore, as on date, no, my lord, right has been crystallized. So that, my lord, application, which, my lord, in my respectful submission is without any locus. They cannot challenge, my lord.
And my lord, I would like to make one small submission, my lord. My lord, by the amended notification, my lord, there is another amendment also has been brought in, my lord. By that amendment, my lord, the OBC, MOBC category seat has been enhanced to 27%, my lord. At page 53, your lordship will find, my lord. Page 53, the second clause number 2, my lord. In clause D, in last line for the punctuation mark appearing at the end of punctuation mark shall be substituted, and therefore the following provision shall be inserted, namely, provided that the percentage of reservation of seats in postgraduate courses under OBC and MOBC category shall be 27% with non-creamy layer certificate. So this amendment, my lord, has been brought in and it has been given effect to, my lord. In the first round of counseling also, my lord, the seat has been allotted on this basis. So this amendment has been already given effect to, my lord. 27% has been increased in the OBC non-creamy layer certificate, my lord.
Anyway, that is not the issue here.
That is not the issue, but the amendment, whether amendment will be applicable or not, my lord.
Whether amendment will be applicable to the petitioner, this is the issue now.
Yes, my lord.
My statement is concerned, my lord. My lord, out of the, my lord, the result declared by the, my lord, NEET, the state list has been, my lord, carved out, my lord. Provisional state merit list of NET PG. There my names appeared in serial number 1756, 1308, 1672, 1813, This is, my lord, so
Where? In this list?
That is the select list, my lord.
This
In
is the
that
select
list,
list.
my lord, their name does not appear. That is the select list. That is vital and it is part of this writ petition.
No, my lord, that list after the first, my lord, round of counseling. This is the, my lord, provisional state merit list. Here from, my lord, all the candidates are eligible to compete for the state quota. So now first round, after the first round was cut-off marks was, my lord, up to 50% for the so far as the general category is concerned, 50.20. And the serial number up to general, my lord, 1578. Up to this much in the first.
No, we are which document are you referring?
My lord, it is not annexed in my application.
You have a copy of that?
Yes, yes.
You have extra copies, one for the.
My lord, may I clarify? This is a integrated, my lord, merit list. Now, out of this merit list, your lordship will see a, my lord, revised, my lord, state, my lord, list is prepared.
Confusing the, my lord,
I'm not confusing, my lord.
out of
Let-
this list,
let-
my lord, he has appeared from this list only. And when he has been selected in the first round of counseling, then the select list has been prepared. It is after the first, my lord, what he is referring to
That
is the
list was
first,
not
my lord,
prepared,
select
yes.
list after the first round of counseling. Now the second round of counseling is going on for the persons, those who already appeared in the first round of council, and they can change the seats, they can change the colleges, etc., etc. Thereafter, whatever vacancy will remain,
Then will
be a notification will be
then
issued.
only, my lord.
Obviously, then only.
Yes.
Now, thing is that they are included in the first round of council or the first select list or the here in the merit above me. But if they do not have the continuous 5 years as required by the amendment, then definitely I'll go up. Or I would have been called, all the applicants would have been called the way already applicant number 1 has been, applicant number 2 has been called for the first round of counseling. There I have opted, I have blocked this seat for orthopedic because I'll again appearing for the second round of counseling if I get the subject of my choice. Thereafter, if I don't get, I may continue, I may leave the quota itself. Then whatever vacancy will arise, it will be filled up from this list on. And there my names are appeared. The first round of counseling, he has also appeared from this. He was in 570, the notice itself, the education
No,
notice.
all of you were there in the first list.
Absolutely. That is not first list, it's a merit list, my lord.
In the
And this is
list.
the select list.
But this,
My lord, that is confusion being created. My lord, may I make it clear? This is not his case that, my lord, he is in the select list. And if I am out, he will be above in the select list. That is not his case, my lord. In the present select list, my lord, his name does not appear. My learned senior should apprise that, my lord, to your lordship. It should be fair. Merit list is a different list, my lord, integrated list. And in the present case, my lord, the select list is annexed, my lord, to the writ petition. He does not, my lord, figure in the select list. It is not the case, if I am out, he comes in. That is not the case, my lord.
my whole case is that all the candidates,
Give me a copy. You have
Yes,
a copy, spare copy.
but all the candidates have appeared as per the merit position from this list. They are
That's
my-
fine, that's fine.
Yes, my-
Unless your name is there, you can't appear in the.
Indeed. So that is my right. Firstly, the first round of counseling they have called in the writ petition itself, my lord.
After the first round of counseling,
Look.
this provisional select list of candidates were issued, correct? This list. This list was issued.
After the counseling was over.
Uh-huh.
Now
In that, your name is not there.
applicant number 2 is there. Remaining are not there.
Applicant number 2 has got his admission.
But he has blocked it. He'll be again appearing in the second round because the choice of subject, if I get in the second round, then I'll switch over to that. Or if I don't get, I may discontinue also. So the seats will be vacant. It is not only in my case, this is the case for everyone. Now second round of counseling is going on. Thereafter the seats whatever available, then again the persons appearing in the list which I have given, my lord, they will be, my lord, eligible to apply for it. Now in the first round of counseling, the persons are there without having the, my lord, 5 years continuous service like him. Not only he, there are many. So therefore, if they are disqualified, I would have been called even for first counseling also. I'll definitely get in the second round. And so far as the state health quota is there, there's altogether 40 seats. That was enhanced to up to 54. Now in the second round, there are 32 seats available. So those who do not qualify for that, then obviously for the third round of counseling, I'll be called from this list. So therefore, I have a right, Mel.
Bora, how many persons are there with less than 5 years continuous service? In terms of that, you have rejected the petitioner's case. That way you'll know.
Only one man.
Or there may be some candidate who doesn't fulfill this criteria, they may not come for interview.
But how many names are there?
That cannot be said, my lord. If they have not come, my lord, or who has been rejected, so it cannot be said.
See, in this provisional list,
Yes, my lord.
after the first round of counseling, the name of the petitioner is there,
Yes, 574.
correct?
Yes.
The name of the applicant number 2 is there, others are not there. Correct. Now what they are saying is, their rights may be affected if the writ petition is allowed.
Yes, my lord, definitely.
Correct. Now, I want to know how many of them are there, just like the petitioners, so that to ascertain whether their rights will be affected or not. After that, I can dispose of this IA.
Definitely, my lord, even for their kid also the right of other candidates will be affected.
Because you are not getting my point.
I think you got this point, but the thing is that, my lord, at this moment, I don't have that instruction. So who are the candidates who are not having the continuous service of?
You get the instructions, then we'll dispose it.
After,
Can you,
after some time, I will.
after some time?
So for second round of counseling, which is going on now, there are 32 seats.
There are 32 seats of HSQ.
SHP.
Correct.
Gotcha. So there may be some more, my lord, during this second round also who do not have the my lord, requisite.
Fine, fine.
Then in the third round, I'll be getting.
It's for the consideration of the IA only, that I want that instruction, that's all. Otherwise, the writ petition is, I've heard enough.
In the writ petition, my lord, what only things what I would like to say, my lord, so far as the rule is concerned.
Yes, unless
I come in.
I hear you, I hear.
Logic.
I can't hear you in the
Logic.
writ petition.
Logic. Okay.
After some time, if he can't take up, then we'll take up tomorrow. Perfect.
Otherwise, my lord.
Otherwise,
my lord-
Gogoi has
Yes.
already met his stand clear.
Otherwise, my lord, the arguments are concluded. So
Arguments
Lordship
are
will pass
over.
pass the
Only for the purpose of IA.
Yes. So Lordship will keep it CFE, my lord.
Well, I want to dispose it now.
Yes, my lord, now. Oh, correct, my lord.
Twenty-eight of daily leave motion.
May I please your lordship? Lordship, in this petition, the petitioner is seeking the benefit under the old pension rules, lordship. Lordship, what happened here, lordship, in the year 1996, there was a select list published. The petitioner was selected as assistant teacher under the LP school of Baksa district, lordship. Thereafter, lordship, the respondents, without maintaining the merit position, they have selected various candidates in different posts, lordship. But the petitioners have failed to get the benefit. Finally, lordship, in the year 2018, the division bench have issued a direction to appoint the petitioner, lordship. And on 3/1/2018, the petitioner was appointed. Thereafter, lordship, the petitioner was put under the new pension rules since it is in the year 2018, lordship. Therefore, lordship, the petitioner herein is seeking the benefit under the old
Yes,
pension.
Kaushik, the notice will hurt MS.
8 Alukta.
8 Aluktal and the concept of petition issue notice. Mr. V. Kaushik, Learner Standing Council, Elementary Education, appears for response number 1.
Response
1. BTC,
rest BTC.
Nayak. P. Mr. P. Nayak, Learner Standing Council, BTC, appears for the respondents 2, 3, and 4. Notice and respondents are complete, however, extra copies.
Lordship,
Respondents
one
are not-
similar case is pending, WPC number 150 of 2022. That will
List the
come
matter of
List.
4 weeks along with WBC number.
150 of 2022. Much obliged, lordship.
29.
May I please, there is third round of litigation, my lord.
Mm.
The petitioner eligible for the post for provincialization of his service in 2013, but was subsequently filed a writ petition. Then writ petition was disposed of, and it was referred to the director. Director did not pass any order. Then we filed a contempt. During pendency of the contempt, the director has passed the order that is at page 62, and it is admitted that I am eligible for provincialization. Page 62, your lordship, I will say. And relevant page 63, my lord, third page.
Yes.
On examination of the entire documents, it appears that the service of writ petitioner would have been provincialized along with other teaching and non-teaching staff of the Bodla Rangapani High Schools if there was no litigation pending at that point of time. Some litigation was pending because of
From the records, it appears that Sri Vilayat Hussain had fulfilled all requisite criteria, provincialization his service under the Assam Venture Provisional Institution Amendment Act. So for eligibility concern, my lord, they have admitted. So Lordship, kindly see the next para, the next to that, the present case is also similar to so and so, and to avoid all legal complications, process has been initiated by the director. In compliance of the order dated so and so, it is my order, passed in so and so by Honorable Guwahati High Court to provisionally service of the writ petition as an assistant teacher asked against third post in Badlas High School. As per provision of laid down in so and so, the same has been moved to appropriate department for concurrence. And because of departmental concurrence was not given, that is why my provincial order has not been issued. And next page, my lord, page 63A, thus the order dated so and so, filed by so and so, will be complied with immediately after receipt of necessary concurrence from the competent department. Till now, my lord, no provincial order has been passed because of non-action. At this stage, instruction may be sought for. Why, my lord, departmental concurrence has not been given?
Yeah, Kaushik. Heard Mr. N. Haq, then the counsel for the petition. Mr. B. Kaushik. It shall receive instructions as to whether the concurrence from the concerned department has been given pursuant to the order dated. Which order date is this? 17/9/2024.
17/9/2024.
Oh, 17/9/2024. Passed by the Director, Secondary Education.
My.
When do you want?
It will be after Bihu vacation.
List after.
Already date may be fixed, not any date, my lord.
Okay, 27th.
Of let's.
52 of supplementary list. Motion.
May please, Lordship. In pursuance of an advertisement, Lordship, this petitioner applied for a post of assistant professor Lordship, of Sanskrit. And along with the response number 6 and 7, Lordship. Accordingly, Lordship, this interview was held on 7th of October 24. Lordship will find the page 48. Page 48 is the Lordship comparative statement prepared by the selection board, Lordship, page 48.
Okay.
Lordship. Here, Lordship, Lordship will find the stage number 8. One Monisha Talukdar, Lordship, she is the respondent number 6 herein. So, Lordship, she has been selected and Lordship awarded marks 67. Lordship will find the right hand side, average marks in cell number 8. And this petitioner's name is at cell number 10. And he has been Lordship awarded marks of 65.58. Now, Lordship, after going through the relevant rules and comparative statement was prepared, Lordship, Lordship will find at page 10 of my petition, Lordship. I have given a comparative statement of marks of petitioner and respondent number 6. And after comparing the marks, Lordship, I have found that Lordship, this petitioners will be given Lordship 65.5 marks. In page number 11, Lordship. Page number 11, total marks to be awarded to petitioner and respondent number 6. So respondent number 7 has been made a formal party, Lordship. We have no grievance against him because he is reserved for the said post, Lordship.
What is it?
Respondent number 7, Lordship, is a formal party. Our grievance is against respondent number 6 only.
Why have you met him a party? 7?
Because what 2 posts were there, 6 and 7 have been selected. So as a formal party, I have met party.
Number 7 is above you?
Yes, Lord.
Where is the number 7?
Number 7, Lordship, in the comparative statement, Lordship will find at serial number 1, there was the Adhikari, Lordship. We have no grievance because he has been given accurate marks on the basis of his educational qualification and interview.
Sanskrit.
Devasi Adhikari, serial number 1.
Assistant Professor of Sanskrit.
Sanskrit, Lordship.
You are.
I am also Lordship same post.
Yes, Chaudhary.
Lordship, here he is claiming on the basis of the comparative statement only. There is no appointment order on, nothing has been annexed here. I'm making a statement only, Lordship. Lordship, at this stage, notice may go.
Because in comparative statement, Lordship will find the right hand column, it has been mentioned as selected. So Lordship, let notice go, Lordship, and for the timing, Lordship, this comparative statement may not be acted upon, Lordship.
Lordship, that may not be done because
How I will know, Lordship, whether the appointment has been issued
because
or not?
he has stated that he has got it through the RTI.
RTI, yes.
So whether appointment has been, that also he could have at the same time obtained it. RTI.
J. Kodikar.
Then the counsel for the petitioner issue notice. Mr. A.R. Tabildar, then standing counsel, higher education, appears for the respondents, 1 and 2.
For
Mr.
only
B.
three.
Chaudhary, then standing counsel, BTC, appears for respond number
3.
3. Extra copies. Petitioner to take steps for service of notice on the respond number 4, 5, 6, and 7 by registered post AD within 1 week from today. List the matter after 4 weeks. In the interim, one post of assistant professor of Sanskrit under the unreserved category shall not be filled up till the next suitable date. One post.
If already they have joined, going by his statement only.
If not already filled up.
And if they have appointed, Lordship, that will update.
Let us see what he comes with on the next day. After that, we'll take.
Item 2 of production list, motion.
My lord, Bora has the instruction, my lord, DP Bora.
My lord, till now, only the petitioner has been rejected, my lord. But I am told that, my lord, there is a possibility that there may be some other candidate whose name has been appeared in the merit list, but who has not subsequently appeared before the counseling board, my lord.
Then you do one thing. Let them carry out an exercise. I will take up tomorrow morning and dispose it off.
No, my lord, that can, if they have not appeared, that can.
No, let them take an exercise. This is for the purpose of Psychia's eye only.
No, my lord.
I want to be very sure.
No, my lord. Only the petitioner's case has been rejected. But if someone has not appeared, they cannot say.
My lord, basically,
counseling board.
as on date, there is no other candidate. This is very clear. my lord.
Yes, my lord.
There is no
Petitioner
other
has been
candidate.
rejected.
Yes.
But the candidates who have not appeared before the counseling committee, they cannot say about them, my lord.
Okay.
That is the thing.
So in terms of the select list, only the petitioner.
Only the petitioner has been rejected.
Lordship may dispose it off, my lord.
Then,
Yes.
then Psychia, I can't impute you.
No, Lordship, my serial number is 1308. I have been called for the first counseling along with him. As because this court has, my lord, ordered that the radiology seat shall not be filled up. So though it is my first choice, I have blocked another, my lord, seat for the orthopedic. Now in the second counseling, if it is open, then again I can compete for the radiology. And if he is allowed, if his petition is allowed, in that case, I'll not be getting the chance for the competing for the radiology post.
Because in any case, the provisional merit list name of the petitioner is there.
Yes.
There, my name is also there.
Your name is not there.
So far as applicant number 2 is concerned. Applicant number 2 is concerned.
So far as applicant number 2 is concerned, the applicant number 2 has been given admission.
Yes.
I have blocked the room, blocked the particular seat in orthopedic department.
Oh, okay.
Now in the second counseling, because I could not compete for the radiology because this court has ordered.
Let us see the name of the applicant number 2 in your list.
Quota, sir. Yes, but there is a name, man.
It's for orthopedic seat that has been blocked. I have already filled up my documents for the second round of counseling. And if this radiology post is open, in that case, I'll be competing for that post.
Serial number kiman?
1308.
1308.
No. In this list or in your list?
In my list, 1308. And my name appeared in this, the list produced by him also as his statement, because
Which name? Where's your name?
my name is Indranil Sharma, my lord. Dr. Indranil Sharma.
Serial number?
Serial number? Serial number কি আপনার
That list is not with me, my lord. That was produced by them. And they admitted my mind. That's there.
Give him a copy of the list. Let us not waste any more time. Other councils are also waiting. We'll take up tomorrow. You give the list, we'll take up tomorrow, we'll dispose it tomorrow. Okay. Heard Mr. Estate Alokar, learned counsel for the petitioner, as well as Mr. D.B. Boral, the standing counsel health department, and Mr. K. Gugoi. Then standing counsel already, you see for the respondent 1 and 2. List the matter for the respondent number 2. List the matter for the hearing. Give tomorrow's date as first item.
The interim shall continue.
Interim order to continue. Tomorrow, let us finish it. Bora, you can also try to help.
Yes, my lord, I'm trying to get that.
2 of production list motion, Dr. Akash Dole.
We are obliged, my lord, for giving us this. My lord, the petitioners before your lordships are postgraduate medical aspirants, my lord. They have passed out, they have obtained their MBBS degrees from different colleges of Assam, and all of them belong to various reserved categories like scheduled caste, scheduled tribe, and OBC. So far the reservation is concerned, your lordship is aware that so far OBC is concerned, it is 27%, STP is 10%, STH is 50%, scheduled caste, STH is 5%, scheduled caste is 7%. So total is 49%. Your lordship is also aware that in 103rd amendment to the constitution in 2009, they have brought in another category EWS by which 10% of them has been allotted, of the seat has been allotted to them. But there is a rider to it that so far in the state of Assam is concerned, if you increase, if you give 10% of the seats to economically weaker section, then you have to make a proportionate increase of the seats. And so far Assam is concerned, they have increased it to 51 more seats. But in each and every year, my lord, from 2022, from every year, my lord, the postgraduate aspirants have to come before this honorable court and have to take an order from this court that this 51 seats has to be allotted proportionately among the other candidates. Unless they come to this court, there is no action taken by the DMA. The first such order of this honorable court, my lord, I'll just refer to the 4 years order. The first order of 51 seats, your lordship will find the 11th page is at page 70. It starts with page 64. Your lordship will look at directly at page 70. I do not want to waste much of your lordship's time. Even Well, your lordship will first look at page 62. The first page 62.
Yes.
Your lordship will look at page 62, paragraph number 10 at the bottom. Accordingly, the authorities in the medical education department of the government of Assam may continue and complete the admission process to the postgraduate degree and diploma courses in medical sciences for the year 2020-21 in the medical colleges of Assam by increasing the number of seats subject-wise as provided in column 5 of the table provided in paragraph 58 at page 56 and 57 of the affidavit in opposition of the Medical Council of India. So they said that you have to increase the 51 seats and have to distribute it in the as per this affidavit in opposition. The next order your lordship will look at page 70. This is another order, my lord. This is of 2022, page 70.
1 minute.
Paragraph number 9.
Yes.
Now your lordship will see the authorities in the Health and Family Welfare Department may act accordingly and increase the seats as indicated above. The requirement of increasing the seats be done before the next round of admission so that no inconvenience would be caused to the candidates. Then after that, your lordship will go again to the page number 96, the order passed in the year 2023.
Page
96. Paragraph 11, my lord. At page 96. Your lordship got it, madam? So 51 number of seats has to be increased without specifying any category. Now your lordship will find
para 5.
106.
No, come to para 5, page
Yes.
95.
Yes, madam. Yes. Yes, ma'am. That's there. Now your lordship will see the next
It
year's.
says 25% increase
Yes, ma'am.
in general category,
Yes.
non-reserved category.
Yes, ma'am. Yes. Now your lordship will see the next year's order at page 106.
Next year, 106.
This is the current year, my lord. Your lordship will find that there is a mention of that the state is permitted to increase 51 numbers of seats as indicated. Page 106, sorry, ma'am.
106.
In the meantime, the authorities and the Director of Medical Assam is permitted to increase 51 number of seats for the reserved category, for the unreserved category for the PG medical admission. So this time your lordship has indicated it is unreserved category for 51. Now we have given the seat matrix after this order of this honorable court is from page number 124 to 120. 118, your lordship will find the seat matrix from 118 to 123.
Page
118, my lord. I have given a compilation because I have just indicated the seat matrix from 118 to 123. But your lordship will see the compilation what I have done at page 125.
125.
Yes. First, your lordship will look at page number 124 of the previous year of 2023. Now, if your lordship looks at the chart at page 124, your lordship will find there are total 331 seats, and out of that, OBC 15%, 48, SC 7%, 23, STP 10%, 32, STH 5%, EWS 10%, 32, unreserved remaining 180, total becomes 331. Then your lordship will find the next chart, total number of seats allotted for Assam State Quota as per the seat matrix of second round for the session total, wherein the additional 51 seats were included. Now what's in the first round also included. Now your lordship will see the 51 also. The percentage is maintained.
Okay.
Now in the current year, if your lordship looks into it, in the first round at page 125, next page. In the first round, the reservation is maintained as 27%, 7%, 10%, 5%, 10%. So it is maintained. Now, after the, if now the 51 seats which is given in the second round of counseling, if it is given only to unreserved category, my lord, now your lordship will see the OBC's 27% will come down to 22.71, SC 7% will come down to 58%, STP 10% will come to 8.5%, STH will come down to 4.12%, and EWS will come to 8.5%. That's why we are before your lordship that this percentage should have been maintained just like in the other years for as per the reservation percentage of 27%, 7%, 10%, and 5% and 10%. And your lordship will see, so far OBC is concerned, in the last year also we came before this honorable court. It is only after filing of this honorable court, because in the all India quota for OBC it was 27%. And Assam was following was only allotting 15% for OBC, and that too they were giving it for all this year to all OBC candidates, whereas it ought to have been given to only to the non-creamy layer. So that notification of the Assam government is at page 97.
Yes.
Page 97 is the notification which increases the seat from OBC. So at page 98, your lordship will find. Two, in clause D, provided that the percentage of reservation in the middle, your lordship will find percentage of reservation of seats in postgraduate under OBC category shall be 27%. 27% with non-creamy layer. Assam took all these years to implement the NCL for OBC categories.
Well, you're reading from page
98.
Oh.
In 2, provided that the percentage of reservation of seats in postgraduate courses under OBC, MOBC categories shall be 27% with non-creamy layer NCL certificate. So now your lordship will just take an hypothetical example of if there are 100 seats available. So out of 100, 27 will go to OBC, 10 will go to STP, 5 will go to STH, SC will go to 7 seats. Then it will be 49%. Then economically weaker section, 10%. Then the rest will be divided among the unreserved category. But now in view of this seat matrix, which I have annexed from page number 118 to 123, it takes, if it is implemented, then the OBC reservation will substantially decrease in this coming year, as well as for the other reserved categories. That which I have made the compilation is at page 125. That is basically our case, that if you want to distribute this 51 seats, do it as per the percentage which have been long decided in the reservation case of Indira Shahani, that it should be distributed proportionately among all the reserved category candidates. Rest you give it to unreserved.
See, basically what I'm understood in this batch of writ petitions that have been filed year to year.
Yes, ma'am.
Because the Directorate of Medical Education was not giving the
51 seats.
proportionate after the EWS 10% is deducted, then the unreserved category also the percentage comes down. To cover up that this 51 seats from the very beginning, this court was passing this order.
Yes.
Till I think last month or
yes,
beginning of
what
this
has
month.
happened other day? What has happened in the earlier cases after all these years? They are all aspirants for PG seats. We can't ask them to come to court each and every time. So earlier, it was distributed proportionately among all the reserved category candidates.
By inclusion of this 51,
yes,
this is to see that the unreserved category where their seats have been taken out by all these different categories.
No.
And particularly after the EWS came in with the 10%. For that purpose, the unreserved category, to protect the rights also, they have a right also, that this 51% was brought in. And
not only unreserved, my lord. If you if you increase,
if you see the order
yes,
from the past years,
yes, ma'am.
Because it's not the case that the candidates, these aspirants, they have come only this year.
No,
they've been coming from the very beginning.
Yes, there is a difference. In the early years, they came before the first round of counseling. From the first round. And this year, they thought that since all these years, the DME was distributing the seats among all the reserved category candidates. That's why they did not come in the first round. It is only in the second round now when the matrix has been changed. That's why they are before your lordship. There's a difference, my lord. Because in the earlier orders, your lordship has not indicated that it is for any particular category. This time, your lordship has indicated that it is for unreserved categories only. That's why we are before your lordship.
Page 124 and 125.
Yes,
is this a chart prepared by the respondents or by you?
My lord, we have compiled from the seat matrix page 125. Because if your lordship looks into the seat matrix, then it will take lots of time for computation. But this 125 has been prepared on the basis of seat matrix from 118 to 124. Just for easy understanding for all of us now.
Yeah, Bora.
My lord, we have done as per the definition partially honorable.
No, that's easy. It's very easy to. You should explain.
Regarding that, I have of the inspection now, that before something kind of.
NMC.
Lordship, the stand of the NMC is limited only to the aspect that what number of seats providing the infrastructure and the facilities that are available, what is the number and the figure that is permissible to be increased in the state of Assam. That figure, Lordship, already established, that figure is 83, my lord. And of those 83, in the previous 3-4 years, the state, for reasons based on, my lord, they are asking us for 51 of those seats. As 51 is a figure under 83, my lord, NMC has always allowed it. And this time also, my lord, because I think the OBC seats, the percentage has been increased up to 27. So we are stating that if you ask for up to 83, then that is permissible. As my lord, in the previous order, Lordship has very correctly pointed out that this notification of NMC means that 83, that is onwards from 21. However, my lord, as regards to the distribution, my lord, that would be the prerogative of this honorable court with assistance of the state respondents, my lord, because NMC is just a, my lord, academic body, my lord, looking into the academic infrastructure, my lord. However, it appears to be a compensatory, my lord, measure for increase of EWS.
Chowdhury, you are
My lord, I'll just give, before my learned senior, I'll just give the one stress of the example. Suppose there are 100 seats, 27%, it's okay. Now, if you increase the seats to say 110, that 27% has to be calculated on the basis of 110 seats. That's our case. Not 100 the earlier one. Because you have increased the seats. If you want to increase the 81 seats, now is my learned friend has said that they can accord permission to 81 seats. It's good. We need more doctors. But if you increase that 81 seats, then this 81 seats has also to be divided proportionately among all the reserved category candidates. Otherwise, the percentage, that 27% will go down. Just for example, in case of OBC, it will go down. And till the last year, my lord, OBC was given 15% only in a reservation. Whereas in the All India quota, it was 27%. And state of Assam was giving it to all creamy layer students till last year, my lord. So it needs some deliberation and examination by the state also. But your lordship will see that our rights are also protected, because now that seat matrix, everything is going on. They have given a schedule, my lord. I have page 100 is the schedule, my lord. Now your lordship will find at page 100, second online filling of choices is going on, my lord. 15/12 to 19/12/2024. Because if once it is allotted, my lord, I don't want anyone to have a false hope that they will get a seat, then we'll make party, they should not lose the shot. That your lordship will kindly keep it in mind and protect the interest of me.
My lord, I'm appearing for 3 respondents. They have made party. I think respondents number.
Private
5, 6,
respondents
and-
are there?
Yes, 5, 6, and 7. We have instructions to appear for 5, 6, and 7. Now, my lord, my first submission is this action has been taken pursuant to lordship's order. Now, until and unless that order is reviewed, varied, or appeal is preferred, my lord, nothing can be done. First. Now, let us come to, my lord, the merits of the case. Now, what is the case of the petitioner? What my learned friend is arguing is opposite of what Article 15(5) and 16(6) says. Please take the Constitution for a moment, my lord. My lord, if they have any claim, don't entangle us. Don't entangle EWS. Do whatever you like. Ask for the moon. We don't have any objection. But don't bring us, because we are in a different pedestal altogether. Please have the Constitution, my lord. The absolutely misconceived case, my lord.
Yes.
Please come to Article 15, Sub-Article 6. Nothing in this article or subclause Z of clause 1 of 19
or clause 2 of Article 29 shall prevent the state from making any, please come to B. Article 15, sub-article 6, clause B, my lord. Any special provision for advancement of any economically weaker sections of citizen other than mentioned in clause 4 and 5. This clause 4 and 5 are the people whom my learned friend represents. So this reservation is for other than clause 4 and 5. Insofar as such provision relate to their admission to education institution, including so-and-so, etc., which in the case of reservation would be in addition to the existing reservation and subject to maximum 10% of the total seats in each category. Now please come to sub-article 6 of Article 16.
Yes.
Nothing in this article shall prevent the state from making any provision for reservation of appointment or post in favor of any economically weaker section of citizen other than classes mentioned in clause 4, in addition to existing reservation, subject to maximum of 10% of the post. So, my lord, 103rd Constitution Amendment was a measure aimed at doing a particular, creating a particular class of economically weaker section. They are not social reservation, my lord. These are not vertical reservation which we normally understand. Now, what had happened? Now, please come to page number 62. Sorry, page 60. Para 8. Accordingly, we are inclined to consider the passing of an interim order without expressing any view on the merit of the legal issues raised. For the purpose, we take the note of provisions of para 58 at page 56 and 57 of the affidavit in opposition of the Medical Council of India, where number of seats subject-wise approved for an increase for the year 2021 had been provided. The said table is extracted below. Subjects, say for example, my lord, medicine. Now seat available for 1920 was 39, of which reservation was 37%, and my lord, open merit was 24%. Now, my lord, 37% of 39 is 14.48, approximately 15. So when we deduct 15 from 39, what follows is 29. And kindly see the heading, open merit seat unreserved in state quota. This is the affidavit of the National Medical Commission. Now they say what is required is 6 number of seats in medicine is required to be added. Well, this is not meant for everybody. It is meant for unreserved seat. Now, in the earlier years, what the DME was doing was, my lord, he was playing that googly, Chandrasekhar googly, taking help of the court's order and doing, my lord, all, I would say, absolute nonsense. What they were doing, they're distributing the seats, which could not have been done. This increase of 10%, be it, my lord, 51 or 83, this is a compensatory reservation. The idea is to compensate, not to disturb the existing reservation. So in such a scenario, where is the scope for alleging any grievance by a socially reserved class, my lord? This seat is not meant for you. Earlier you may have got the earlier wrongs cannot, 2 wrongs cannot make a right. That's why, my lord, while lordship's passing the order, we specifically said, please mention the word unreserved. The idea is this benefit must percolate only to the unreserved. So they cannot have any grievance. Their entire case, in my humble submission, subject to what your lordships may say, is absolutely misconceived. Now, my lord, I have read the provisions of 133rd Amendment. Where is the scope to make all these arguments? You are a beneficiary of a vertical reservation. Now, a 10% has been made earmarked for economically weaker section. Now that economically weaker section does not include X, Y, Z, everybody. It includes only in the unreserved seats. So therefore, having regard to page 60, the stand of the NMC and the very fundamental premise on which the first interim order was passed, where is the scope to tinker with this, my lord? When it says out of 39 seats for medicine, when 37% reservation is deducted, then what remains is 24 seats. And 24 is meant for whom? For the unreserved. To which what was added was 6 more is required as a compensatory reservation. So, my lord, where is the question of vacating that? I mean, passing an interim order at this stage? Should we examine the matter? Since a legal issue has been raised, but I don't think, my lord, lordship will jeopardize the life of. Already lordship has passed an order. Every year the students are coming before lordship. Yes, the state authorities should have made their position clear at the very beginning. They were not doing it. There were some area left for, my lord, leg room. Now, by putting that word that this will be confined to unreserved, now everybody is in, my lord, fallen flat. And that's the correct approach towards approaching this problem. So therefore, my humble submission is, my lord, this page 124 and 25, this is the submission of the petition. So that your lordships will consider that. I am not saying he cannot make that. He has every right to make the submission based on the chart prepared by him. But that will be a call which lordships will take finally. And my lord, is it the case of the petitioners that while making provision for these EWS, their seats were taken away? Is it their case? So therefore, in my humble submission, my lord, if today lordship passes an interim order, there will be chaos.
No, I'll be reviewing my earlier order.
But for that an
No,
application.
no. If I pass an order today.
Yes, lordships will be reviewing our lordship's earlier order without an application.
That's what I'm.
Correct.
My lord, let me hold that. Now, first, let us understand how this economically weaker section comes. Your lordship must have gone through the judgment reported in 2022 SCC online, SC 1540, Janhid Abhiyan versus Union of India, where this 10% reservation sits under Article 15.6 and 16.6 has been upheld. Constitution validity has been upheld. A submission has been made by my learned senior friend that it is compensatory distributions of seats. My argument will be that it is not a compensatory distribution of seats. Compensatory distribution concept will come only when you take some seats from the reserved category and give it to the others. Here, so far 10% seats is concerned, Malad, these 10% seats were not taken up from SC or ST. Malad, if it redistributes the other categories.
So where was it taken out from 10%?
Malad, it was increased additionally. And our case is that this addition, it was not taken out from SC, ST, Malad. That
none of the reserved category were affected by this 10%.
Yes, yeah, but if it has been taken out from there, then only it will come the concept of compensatory distribution. This compensatory distribution that argument is coming,
this
it is not compensatory.
Distribution relates to the unreserved category.
Yeah.
My lord, this compensatory concept will come only if seats are taken from us and given to them. That is compensatory. This compensatory concept which my learned senior is trying to urge upon this court is not compensatory. It is non-compensatory. And my lord, if suppose, my lord, say for EWS quota, my lord, it is given only to the unreserved category. My lord, then how the state will maintain the 27% of the reservation? That is not the law. You have to have the 20% reservation, 5%, 7% and all. Now, if you increase the seats from 100 to 105 and you say that these are compensatory seats, that's why it cannot be allocated to other categories. That's why this has to be go only to the unreserved category, or only to the unreserved. my lord, that is not the interpretation of the law, my lord. These are all.
That we can consider,
Ah,
we can consider
But,
later on.
but your lordship will see, your lordship has to protect the interests of this petitioner, because once the seats are allotted, why we have come out today? Because after the order of your lordships, there are subsequent amendment, subsequent development. Today, it was not necessary for us to make them a party in the petition. These three petitioners were party in the original, last writ petition. That's why we have made. We don't want to take an order by playing hide and seek with the court order. We have made them a party. On 19, we'll get ourselves implemented in that petition also, when we'll get, we'll address that court on that particular petition also. But today, if we don't come immediately, and once this process is over, we'll have our whole rights will be prejudiced and we'll suffer irreparable loss, my lord. That's why we are before your lordship, because unless this, your lordship determines that how this EW's 10% of EW seats are to be distributed. Today, if it is distributed to all the unreserved category candidates, then third party rights will accrue, my lord. The whole color of the litigation will say. So another 2 days will not, heavens will not fall, my lord. They have time. My lord, your lordship will wait till 19. And my lord, till 19, your lordship will pass an interim order in this case and tag it along with the other matter, so that the status quo will be maintained till 19. And on 19, we'll file an application in their case also, my lord.
Mr. Konwar.
Yes, my lord.
I can admit this writ petition to look into the legal issues involved, but I can't pass an order today.
No, your
I
lord.
can't pass an order protecting the petitioners in the present writ petition.
No, my lord, if the seats are, if
My mind is clear.
my lord, let me, my lord, your lordships has made up his mind. It's fine. But I can only try to make an endeavor to submit or to satisfy your lordship why our rights is need to be protected till 19. Only 2
So
days.
if you want it, we'll take it up on 19.
But
We'll
your
take it up
lordship
on
will
19.
ask them that 19 process, after that 19 process, they will not pursue.
That we can direct them to extend the period. If the court wants it, court can give a direction.
That
There's
your
not an
lordship
issue
will,
on
that till
There's
19.
not an issue on
No,
that.
your lordship will see page 100. Page 100 once more.
This I've seen. This we've seen.
So your lordship will see the
Court has the power to give a direction extending the period.
No, my lord, your lordship they will allocate the seats after 19.
So that's why I'm saying on 19 will take up the matter also, along with the other writ petition, which is.
No, but your lordship can observe that this process at page 100, your lordship will just look at page 100 once more.
How?
Online filling of choices is filled 15/12/2024 to 19/12/2024. Online locking of choice is from 19/12/2024 to 4 p.m. So till second, my lord, till 19.
Online locking of choice is 4 p.m. to 11:55 p.m.
Yes, ma'am.
So by the time we finish this matter,
Yes, ma'am.
it will be over.
Yes,
So there's not an issue on that. So we'll list it on 19th if you want it.
No,
If you, I can issue notice, ask them to file affidavits.
No.
If
my
you
lord,
want,
say,
or
my
if
lord,
you want it
my
considered
lord,
on
this is
19th,
only an
you can have it.
adversarial litigation. We as a councils, we may today represent the petition.
I understand.
So we are here to assist your lordships in delivering justice. We should not pass an order which will not be legally sustainable. Because today I am appearing, say for example, today I am appearing for the petitioner. My daughter belongs to the unreserved category and she is also a student who is seeking for that unreserved category. But even then I have come and said that this unreserved category should not go to 51 and it should be distributed among all the categories. Today, when I go back my home, it will be difficult to face my daughter if she is watching the online that my father is arguing against my interest. But that's the duty of a lawyer.
See, Konrad, for that respect, I come from the reserve category.
Yes, all.
I could have passed an order today.
Yes,
protecting the
Yes,
reserve
madam.
category.
That's why we don't.
That
Yes,
is not the
madam.
issue.
That's why we don't have color. Madam. We don't have color. That's why I'm telling that madam, your lordship will take up on 19.
No.
Your lordship will keep all the options open. In 19, we'll address and we'll also file an impleading petition in
That's
Mr.
fine, that's
Chowdhury's,
fine.
case by tomorrow.
But Konwar, I'm saying one thing, that I am not passing any interim order.
Your lordship will keep the interim order option on 19 after
Okay,
hearing.
that
Yes,
we can
yes,
hear it.
yes.
Heard Mr. B.T. Konwar, Learned Senior Counsel, assisted by Mr.
P. Dole, Lordship.
P. Dolly, Learned Counsel for the petitioner. Also heard Mr. D.B. Bora, Learned Standing Counsel for the Health Department for 1 and
120, my lord.
123, Mr. G.K. Batial, Leonard Standing Council NMC for respond number 4. And Mr. K.N. Chowdhury, Leonard Senior Counsel, assisted by Mr. K. Batori for the responses 5, 6, and 7. Stop. Next the matter again on 19th December, huh?
In the motion column, my lord.
Yeah, it is.
Well, you
I'm
must-
not issuing notice.
Yes, ma'am, in the motion, column.
In the motion.
Along with WPC number, my lord.
No, that is coming up.
Otherwise also done.
It's coming up.
Deep Lord.
We are obliged, my lord, for giving us special.
3 of production list, Neetu Singh Borgoyari.
The senator protection list. I don't, yeah.
3 of production list, Neetu Singh
happened?
Borgoyari versus BTC.
It was mentioned in the morning.
No.
Then? From where is it come? Before which court? Well, let us keep it for pending for some time. Let's see if the council comes.
53 to 56 of supplementary list ordered.
Lordship, it was kept today for instructions. But Lordship, may I just take a moment just to clarify the factual position? And if-
Actual position clarification not required, Lordship, may kindly pay. It's because time is so, they are safe, Lordship. So, Lordship may,
Then we have no.
They are safe.
yes, because the persons who were ousted, Lordship, 9 person, they, against their push, Lordship, push, as per Lordship's direction, regular election was done, Lordship, and against their push, they have appointed. So they are released. In that particular push, no one was appointed, Lordship, at a relevant point of time. So at this moment, they are safe, Lordship.
Our problem is we don't know what at this moment means.
At this moment means, Lordship, if regular selection is done, Lordship, they will be replaced by the regular appointee. Otherwise, TF should not, TF, they have to, if they wants to regulation, they have to participate in the process, Lordship.
Which para is it? All this, I have to go through all this.
Lordship, my lord,
Okay.
kindly this one also. Lordship.
1 minute.
Only, that I can deduce. In 3 cases, 3 instruction is there. Lordship, may kindly peruse this one, Lordship.
All the 3 cases, they are protected.
They are put, only 9 persons.
4 cases.
4 cases, Lordship. 9 was, Lordship, already released. List is there, Lordship.
Yes, we've also filed the list.
List is there, Lordship.
Where is that list?
We have annexed.
Lordship, in our IA,
We
it's
have-
page
We have
40.
annexed. We have annexed.
We've also annexed, page 40.
All polytechnics.
All polling. That was done as per Milo's direction. First paragraph, it specifically mentioned, Lordship. As per Lordship's direction, it was conducted the interview process. Instruction to get, not get. একটু ফোন টুন দেখেন একটু উল্লেখ শুনি একটু ঠিক আছে কোনো দুইটা দ্বীপ থাকে নেক্সট কিটা হলো And my lord may put another query also, Lordship. My lord has also yesterday put one query also, Lordship, that whether the present cabinet decision is applicable or not. As because they are already in TF, Lordship, that's why that is not, not under that. Already TF, Lordship.
So here what you are saying is,
Lordship.
the case of the petitioners need not to be taken under the zone of consultation in accordance with the cabinet
Lordship,
decision.
they're not
Correct.
required, Lordship.
Dated so and so
Lordship,
for engagement on ad hoc basis against sanctioned posts
Lordship,
as per regulation 3F of APSC,
Lordship.
as they are already
Already in the
engaged
TF.
and having been serving as lecturer in polytechnics under regulation 3F.
TF,
So you are safe.
Yourself, if Lordship regular process is Lordship carried out.
So I can issue a notice and then you file your affidavit.
Lordship will record the statement that we will not.
Lordship may keep the instruction as a part of the record, Lordship. Lordship may posted it for final hearing. We will argue it on the basis of the claim in the writ petition, Lordship. Whether they are entitled or not. Otherwise, Lordship, at this stage, Lordship, nothing will be happen. My lord's direction, we have exercised and completed the process. 9 persons we have found that they are pushed in the covered post of the Lordship's direction, so they are released, Lordship.
Lordship will record this. That is all that is required.
No, I'm going to record what is stated here
Lordship.
for your satisfaction.
Obliged, Your Lord.
Fine.
Yes.
Then all the orders will be the same.
Same,
Yes, Your
Lordship, same, Lordship, same.
Yeah, alarm. Item 53 to 56, is it?
Yes, Your Lordship.
I know. In the IAS. Huh? In the IAS. You just say Hart MS G. Goswami, London Council for the applicants. Stop.
Lordship, if Lordship permit, I can leave, Lordship. One matter is going on.
Okay. When do you want it?
Lordship, any day after 4 weeks, after view vacation.
Okay, you want it after 4 weeks?
After view vacation, Lordship.
They haven't filed their reply.
After view vacation.
Pleadings may be
In the
completed.
meantime, Lordship, we will file it necessary, we will file, Lordship. Otherwise, after view vacation, Lordship may fix it.
Okay.
Lordship may allow me to leave.
Okay. You want a date fix or after BU?
After view, Lordship.
So I'll give it, I'll say after list after 4 weeks.
Lordship,
Okay.
Lordship.
Okay. Hart MSG Goswami, Learner Council for the petitioner, for the applicants. But by this application, the applicants, you are the writ petitioners, correct?
Yes, Your Lord.
Who are writ petitioners in WBC number 1264 of 2023 are praying for direction to the respondent authorities not to release the applicants from service appointed as lecturer under Regulation 3F of the Assam Public Service Commission within bracket limitation and function close bracket Regulation 1951. Stop. Para. Considering the prayer made by the applicants in the present IA, comma, Mr. K. Gogoi, London Standing Council Higher Education, was directed to take instructions on 16/12/2024. Stop. Para. Today, when the matter is taken up, comma, Mr. K. Gogoi, London Standing Council Higher Education, has furnished a communication dated 17th December 2024, written by the Director of Technical Education, Assam, and the relevant portion is extracted here and below. Page from A to A. I'm extracting the whole so that you are safe. Okay. Stop. Para. In view of the instructions content in the communication dated 17 December 2024, comma, issue notice. Mr. It will be Gogoi who will be appearing? Mr. G. Gogoi, London Higher Education, Standing Council Higher, appears for the respondents. 1, 2, 3.
In the IA, my lord.
It will be 1, 2, and 3. All the respondents are same in the other IAS or
Yes,
they
Your
are
Lord.
different?
Same, no?
Otherwise, there'll be some problem, because,
Lordship, there are
okay, let
three-
us go one by one.
okay.
This is item. One,
Lordship, there
two,
are
six.
4 IAs and 4 writ petitions.
Oh, this is IA 3712.
53.
My lord, in
Okay,
IA 3712, I will be appearing,
you are appearing or Gogoi is appearing?
go, my lord, 1, 2, 3, and 6, my lord.
Assam Engineering Recruitment Service Board.
Yes, my lord.
To take it on my point.
Oh, 1 minute. Are you appearing for the recruitment board also?
Yes, my lord. This is under technical litigation.
Okay. Respond 41, 2, 3, and
1, 2.
6. Finance,
Finance, my lord, B go.
Mr. B. Gogoi, Learned Standing Council Finance, appears for respond number 4.
My lord.
Opposite party, huh? No, don't say this. For the opposite party number 4. And MS, PB Das, Learned Council appearing on behalf of TJ Manda, Learned
3711.
Standing Council APS.
Yes.
For the respond number 5. Stop. Notice on respondents are complete. However, extra copies of the present IA be furnished to so and so. The respondents are allowed to file their respective affidavits. Stop. List the matter after 4 weeks. Okay.
3711.
And in the writ petition,
Lordship, that IA was in writ petition 1264.
no,
of
any order
23.
is required in the writ petition.
Not required, Lord.
It says list on 1612. So, heard MSG Goswami, Learned Counsel for the petitioner. In the writ petition. On request made by Mr. K. Gogoi, Learned Standing Council Higher Education. You have not filed affidavit, isn't it?
No, my lord, I have not filed.
4 weeks time is allowed to file affidavit, list after 4 weeks. This is one. Give me the other one.
3711.
3711. It's Polytechnic, right?
3711.
Lordship, this is in same writ petition, right? Writ petition.
1, 2, 6, 7.
1, 2,
5.
3, 6. Same order.
Same order.
Same order in the writ petition also.
Parties
And
are
then
also same.
item number
53, right?
55. IA 3713.
It's a 3713, right? 3713 over here.
3711.
Oh. Here it will be Gogoi, huh? For 1,
Man, that's right.
2, 3, and 5. No,
No. 1, 2, 3, and 4, my lord.
1, 2, 3, and 4.
Lordship, 3713 is not Polytechnic Engineering College in the main order. Am I?
I'm not
Yes.
mentioning politics.
Okay,
no.
yes, yes, Lordship.
1, 2, 3, 4. Huh?
1, 2, 3, 4. My lord,
And
it's
5, the TG Manda, respondent 5. Huh? Writ petition, same order. And item 56, 3715.
Same, my lord. 1, 2, 3, 4.
1, 2, 3, 4, and TG Manda, so and so, 5. Writ petition, same order.
Lordship, by recording our prayer, your Lordship mentions only Polytechnic. So they should not read it as our prayer was not also for engineering. The first,
What is it? Praying for?
not to be released from.
So
Okay. About Polytechnic or
I didn't say anything.
no, not like
That's
Yes.
it's safer for you.
yes.
Okay.
Yeah. Oblige, your Lordship, oblige.
This one is over, huh? Oh, 1 minute. What is this?
Four instructions are there, my lord.
All are same or different?
Same, my lord.
Huh?
Same, my lord.
No, no, no.
Lordship, there are 4 IAs and 4 different writ petitions.
Yeah. This one is.
My lord, the third para.
This IA number 3712 and 3711, na?
Yes, ma'am.
That will be the same. Okay. And IA 3713 and 3715. It will be different. It will be, I'll just say B to B. Here also you are protected, but
Yes, madam.
it's a little different.
Sorry,
Instruction are a little different.
for the engineering colleges,
Uh,
Themaji Engineering College.
oh, it is not mentioned here.
This is my lord, engineering college.
Engineering colleges. Same. Protection, little difference is there, but then protection. So you have to, you're good enough.
Oblige, Your Lordship.
Okay. Hmm? Is it? Then how do we? Hmm. Then you send it the better use. Huh? Okay. This production list before the appropriate bench. Today itself? Huh? Okay, list before the appropriate bench.
Of daily list, implement of party.
My pleasure.
How many letters?
It's for implement of respondent number 8 as necessary party, Lordship. It is the director of pension
In what? In the writ petition?
in the writ petition, Lordship.
Why do you want to implement?
Because the director of pension is the appropriate authority to release the pensionary benefit to the petitioner, Lordship. This writ petition is for entitlement of arrear salary and pensionary benefit, Lordship.
Okay. Yeah. Heard, Mr.
MK Naik, Lordship.
Learned counsel for the applicant. Also heard Mr. P.K. Bora.
Elementary education.
Learned standing counsel in elementary education for the opposite party. Number
1, 3,
1,
4,
3,
5,
4,
and 6, ma'am.
5, and 6. Mr. Finance B. Gogoi. Learned standing counsel finance for the opposite party. Number 2. And Mr. What do you call that? B. Sharma, Accountant General.
Accountant General. Estimate.
D.
Bishop Robert.
R.K. Talukdar. You are Accountant General?
Yes, sir.
Mr. R.K. Talukdar, Learned Standing Counsel, Accountant General for respondent number 7. By this application, the applicant who is the petitioner in WBC number 5019/2024 is praying for implement of the, within inverted commas, you said, Director of Pension, comma, Assam, House Fed Complex, comma, Dispur, Guwahati, dash 781006, page 4, 8A. As party respond number
8, Lord.
8. On the ground that the said proposed respondent was inadvertently no, that the applicant could not make the proposed applicant due to inadvertence as a party respondent in the said writ petition due to inadvertence. Stop. Para. This court has considered the caution in the present application is satisfied. Accordingly, pray for implement is allowed.
My lord, estimate direct to
In the main writ petition, in view of the order dated so and so, let so and so be implemented as party respondent number 8. Stop. In the present writ petition, petition is directed to file an amended cost title within a period of 1 week from today. Stop. Government advocate, who appears? Have you served a copy on the government advocate?
yes, Lordship.
Where is the government advocate? Mr. P. Saikia, the government advocate, enters appearance on behalf of the newly implemented respond number 8. Stop. As such, no formal steps are required. The learned government advocate appearing for respond number 8 prays for 4 weeks time to file affidavit. Praise the Lord. List after 4 weeks.
Alright.
In case of my name, my lord, B. Chakravarti name may be repeated. He is the council.
Who?
He is
B. Chakravarti.
B. Chakravarti.
P. Chakravarti, huh? Instead of R.K. Talwalkar.
31, admission.
The state respondent is supposed to file the affidavit as per last order. They have not filed affidavit, last order is there.
Yes, Bora.
Need some time on that.
I knew it. Yes.
Pending since long, Lord. I'm respondent 8, Lord. If I press suspended, case is pending since long. Since
Have you filed your affidavit?
They have filed that.
You filed
yes,
it.
Lord, I'm fine.
Heard Mr. P. Borgastel and the counsel for petitioner, as well as Mr.
J.M. Sulaiman, respondent 8.
J.N. So and so, huh? For the respond number 8. On request made by B.K. Bora, Learner Standing Council Elementary Education. How much time? 3 weeks.
A short date, my lord.
3 weeks time is allowed to file counter affidavit. List the matter on
First week of
22nd. First week, many cases are fixed.
First week of February, my lord. I must.
January.
In January, I put so many cases fixed, my lord.
Okay, then list the matter after 3 weeks.
Yes.
32,
Matter pertains to my lord proportionate pension. My lord, 2019 matter. Well, the matter has been listed. They are seeking time again and again, my lord.
Affidavit in opposition.
Only 4 and 5 has submitted their.
4 and
affidavit.
5.
I have received instruction, my lord, today only. Kindly, this after vacation, I'll file affidavit. I have received instruction today.
Okay, yes.
My lord, then my
And
lord,
as
fixed
per-
date may be
As
given.
per inspection, my
But
lord,
S. Chowdhury, Learner Counsel for the petitioner. Mr. S. Das, Learner Standing Counsel, Higher Education Department, submits that he has received the instructions and prays for some time to file affidavit. Praise the Lord. List on 24th January.
Develop.
33,
May be lordship. Last occasion, the lordship is directed to produce an instruction on Mr. Sharma was there, U. Sharma.
Lordship, I have received an instructions where it says that the petitioner name was not listed in the cabinet memorandum based on the report received from the concerned district officer.
This court gave a direction whether the cabinet memorandum was approved by the
yes.
cabinet. I didn't ask whether the name of the petitioner was there in the cabinet memorandum. Okay. It was approved.
Yes, sir.
Yes,
It was approved, but
And list, my case is totally different. List was approved. That is, record also says my petition, the list was approved. Lordship will find the cabinet memorandum.
Are you ready?
no, your lordship is taken care by you, Sharma, your lordship.
Where's you, Sharma?
It's not here today, your lordship. It's taken up on
Third Minister, B.B. Barwa, Learned Counsel for the petition. M.H. H. Tredangpi, Learned Standing Counsel Secretary Education, has furnished a communication dated
17/12.
17/12/2024, written by the Secretary to the Government of Assam, Department of School Education, wherein it is stated that the cabinet memorandum annexed in the writ petition was approved by the cabinet on 21/3/2020, and accordingly notifications were also issued. Stop. It is also is stated that the name of the petitioner was not listed in the said cabinet memorandum based on in the said cabinet memorandum. Stop. Para. The communication dated 17/12/2024 is placed on record. Para, on request made on behalf of Mr. U. Sharma, Learned Standing Counsel, Secondary Education Department. When do you want? List after the winter vacation.
Fix the date, Lordship.
Now, list the matter on 27 January.
And next date, already Lordship directed her. Today, Lordship directed for cover cabinet. Already the cabinet member approved it on the and the because and the record to be produced. The record relating to the rejection.
List on which date the Learned Standing Counsel Secondary Education Department shall also produce the records.
It record relating to pertaining to the order dated to 2nd December.
Yes.
34.
May I please? Basically, this writ petition, two prayers have been clapped, Lordship. Kindly see, page 10 is the prayer. Now, first prayer is the area salary. That at least can be paid to the petitioner. Page 10. And so far, pensionary benefits are concerned, that will take some time. We understand that situation. But so far, area salary is concerned,
True, my lord. I need some time. I have not received any instructions.
At least with regard to the area salary, on the next date you get some instructions.
My lord.
Otherwise, you will pass on order. Third, M.E. Mondal, Learned Counsel for the Mr. P.K. Boral, Learned Standing Counsel Elementary Education Department. Prays for some time to enable him to receive instructions. With regard to the area salary of the petitioner, with effect from 1/1/2021 to 14/9/2013, and also the pensioner benefits with effect from 15/9/2023. Stop. Praise the Lord. When do you want?
Tenth of January.
10th. Okay, list the matter on 20 January. MS A. Sharma, Learned Counsel, appears on behalf of Mr. B. Sharma, P. Chakravarti, Learned Standing Counsel, Accountant General, correct?
Oblige, sir.
35.
May I please, your Lordship? This matter has been listed at our instance today because of some urgency. Lordship, this issue has already been decided by the Honorable Court, Lordship. With regard to acceptability of the MA degree. I have obtained my MA degree from distance education mode from Dibrugarh University. Lordship, it is already covered by judgment of Tankeshwar Nath, and this was followed in Kollan Das. This is the second round of litigation. May kindly see the first order passed by the Honorable Court at page 53, Lordship. Mosumi Soria's case was also, Lordship, mentioned here. Sorry, Lordship. Page 70, Lordship. Sorry, page 70. Page 70 is the first order, Lordship. May I read this order, Lordship?
Yes.
Heard so and so. The petitioner seeks to be the in-charge principal of Padmaram Sharma High Secondary School, Bandhavur, Titapur in the Jorhat district, stating that otherwise, for all purposes, the petitioner has the requisite qualification and eligibility as per Rule 12 and 18 of the Assam Secondary Education Provincial Service Rule 18 for being a regular principal of the school. The petitioner is agreed by order to the 4/10/2023 of the Director of Secondary Education Assam, wherein while considering the claim of the petitioner to be the in-charge principal, it stood rejected by providing that the petitioner had obtained her master's degree from Dibrugarh University during her service period without prior previous permission from the appointing authority. And as such, her MA degree is found to be unacceptable in law. The relevant provision of the order dated so and so is expected below. So it was thereafter, Lordship, discussing Lordship Mosumi Soria's case. Lordship, may kindly see page 71.
Yes.
Paragraph 4, it is no longer res integra that even if a qualifying degree is obtained by a government employee without obtaining prior previous permission from the appointing authority, the same at the base may be a misconduct, but it cannot be a reason that the degree itself will be an invalid degree. In this respect, reliance is placed on the judgment and order dated 28/9/2023 of this court, rendered in I civil number so and so. Accordingly, by relying upon the proposition laid down in the judgment and order dated 28/9/2023, the conclusion of the director in refusing to accept the MA degree of the petitioner to be a valid degree and accordingly rejecting the petitioner for being the in-charge principal is incorrect and contrary to the provision of law. In view of the above reasoning of rejecting the claim of the petitioner for being the in-charge principal, by order dated 4/10/2023 is set aside and the matter is remanded back to the Director of Secondary Education Assam for a fresh consideration on the claim of the petitioner. In doing so, the director shall take note of the proposition of law laid down by this Honorable Court in his judgment dated so and so. Thereafter, Lordship, it was also noted, Lordship, I had taken permission from the Inspector of Schools. It is also on record, but not from the appointing authority. It is a fact that I did not obtain permission from the director, but from the Inspector of Schools. Thereafter, Lordship, this impugn order was passed.
Where?
At page 76.
Yes.
Lordship, it reads like this, Lordship. Long order. In Lordship, may I skip this order? In view of the above direction has been issued to all the Inspector of Schools by this letter for royal of departmental proceeding against the teaching and non-teaching staff of provincial schools on notice of violation of the Rule 13 of 1965 and impose penalty as prescribed under Rule 7 of the Assam Services Discipline and Appeal Committee following due procedures prescribed in the said rule. In this particular case, the MA degree of Sri Mitali Sonwal is unquestionably a valid degree. However, she could not produce any NOC issued by the appointing authority granting previous permission for acquiring her MA degree. The petitioner submitted a copy of application stated to be submitted to the Inspector of Schools JDC Jorhat, praying for prior permissions to study MA, which does not bear the official receipt number and official seal and cannot be considered as no objection certificate. The Inspector of Schools Jorhat by letter dated so and so has reported that no record regarding issuing of prior permission from the appointing authority to obtain the MA degree in respect of Srimati Mitali Sonwal is found at her office. Thereafter, Srimati Mitali Sonwal has performed a misconduct by violating Rule 13 of the Assam Civil Service Conduct Rules 1965 on her part As such, the inspector of school, being the appointing authority in respect of the assistant teacher of provincial secondary school, is directed to initiate departmental proceeding against Mitali Sonwal. Thereafter, also, I have immediately come before the honorable court. The inspector of schools was directed to initiate departmental proceeding. Before that, lordship, this honorable court has stayed that order, lordship, by the interim order, lordship, the first order.
First order.
So, at on 22/4/2020. Considering the submission as advanced by the petitioner in the matter and also the orders passed by this honorable court in WPC 6938, this court is prima facie satisfied that the impugn order has been so passed in clear violation of the directions as contained in the order dated 5/12/2023 in WPC 6938/2023, as well as similar orders passed by this court on the
Yes,
issue as involved in the
Kiran.
present proceeding.
Lordship, I have received the instruction yesterday, Your Lordship.
Uh,
We will have to file our affidavit, Your Lordship.
So, lordship, this issue has already been settled. I am just placing the judgment, lord. Lordship will only allow acceptability of my MA degree and I am eligible for consideration for the post of principal. That much I am, lordship, seeking from your lord. And your lordship has also recently disposed of similar cases, lordship. I tried to find out but could not, lordship.
Yes,
Give me
Tiraki.
Lordship, I have received the instruction yesterday, Your Lordship.
Then you want to file your affidavit?
Yes, Your Lordship, we will have to file.
Then you file your affidavit on the next day. If it is not filed, we'll dispose this.
Yes, Your Lordship.
Lordship, the only apprehension, lordship, because one of the claimant is also going to retire this month. The inspector of school is presently holding the post. Now, if the director considers some other candidates, I may not be considered because of my MA degree.
Okay.
Except,
We'll list it on the opening day then.
Lord.
Third.
Lord.
Third, Mr. S.K. Das, Learned Counsel for the petitioner. Mr. H. Tirangpi, Learned Standing Counsel. Secretary Education submits that she has received instructions in the matter and prays for some time to file affidavit. Stop. Learned Counsel for the petitioner expresses urgency in the matter. For some time to file affidavit. Prayer is allowed. Learned, after that, Learned Counsel for the petitioner expresses urgency in the matter. Accordingly, list the matter on third.
lordship may kindly observe that an endeavor shall be made to
An
dispose
endeavor
of
shall be
in
made
view
to
of the
dispose of
settled
this
case.
with petition on the next returable date.
37, 38 and 39.
My lord, in this case, affidavit is ready, my lord. The same has been sent for vetting. We're filing on tomorrow, my lord, the affidavit. Otherwise, it is ready, my lord. Actually, the signed copy is supposed to receive today.
You are filing in which petition?
24, my lord.
2789/2024, Lord.
In other two petitions, we have filed affidavit.
Okay. Third, Mr. R.M. Deka.
And Gautam, Lord.
Sorry. And Gautam, Learned Counsel for the petitioner. Copy this second para. The R.K. Talukdar for so and so, and D. Bhattacharya for so and so. Huh? Okay. This in the last order 312. You copy the second. Mr. S. Das, Learned Standing Counsel Higher Education Department submits that affidavit is ready, and the same shall be filed within a period of 1 week from today. 1 week from today. Stop. Affidavit is ready in respect of WBC 2789/2024, and the same shall be filed within a period of 1 week. Stop. Press allowed.
Lordship, may I pray for 9th, Your Lordship?
Please, the
We have not been paid a salary, Your Lordship. That is urgent.
9th January.
9th, Lordship.
40,
Lordship, 40 instructions awaited, Your Lordship.
Lordship, one selection list for regular headmaster is published, Lordship. If the date is not correct for the graduate scale, he will be loser, Lordship.
Yes,
Instructions yet to receive, Your Lordship.
okay, Hurt
So-
MS.
D take a Lordship.
Learning co-
Junior will be promoted, Lordship.
No, any steps are being taken for promotion?
Lordship, scrutiny is going on, Lordship.
So how long will it take scrutiny?
That I'll have to obtain, Your Lordship, how long it is.
Then we list it on the oh God, 70 cases. We list it on 7.
7, yes, Lord. No.
MSS Tirambil and its standing council, secondary education submits. Praise for 2 weeks time to receive instructions. Praise the Lord. List the matter on 7th.
41, order.
The content petition, your lordship order dated 27/11/2020, your lordship, 27/11/2024, my lord, last line, my lord.
27.
11/2024, my lord. Your lordship order, my lord, and Mr. NJ, last paragraph, NJ Khatter Learned Council respondent 2 is directed to produce all relevant documents with regard to the steps taken by the respondent 2 for creation of supernumerary post in respect to the petitioner. And thereafter, my lord, by order dated 6/6/12, my lord, your lordship. Again, they take times, my lord. Mr. NJ Khatoni responded further granted to 10 days time to produce the relevant record with regard to the steps taken by the respondent 2 for creation of supernumerary posts in respect of the petitioner, my lord. In this case, my lord, 2023 division bench, my lord, to dismiss his writ appeal, their writ appeal, my lord. Before judicial. For the
How long will you take?
Well, document, where is document? There is no documents at all.
The documentary thing is there, they've given the file number. This is a contempt.
Yes, fine.
Immediately after the.
Okay, Hurt Mr. N. Boral and counsel for the application. Mr. P.K. Boral and his counsel appearing for the response number 2. As furnished a communication dated 6/12/2024, written by the Under Secretary to the Government of Assam, Department of School Education,
Writ appeal order.
and the relevant portion which is under.
Writ appeal order.
8A. Para Mr. P.K. Bora, learned counsel for response number 2. Praise for 2 weeks time to enable him to receive updated instructions. Praise allowed. List after the winter vacation.
Fixed date, my lord, otherwise.
To come.
Fixed
So,
date, my lord.
2022. Okay, 21st
21st.
January.
Please mention that division bench is dismissed his writ appeal, my lord,
No,
19th.
that's fine, we'll know it.
42,
Well, that documents may be part of the record.
No, the communication dated so and so is placed on it.
March.
Yes, Prakash.
My lord, this review petition, my lord, already lordship has heard. The one thing The order was issued, order was passed, my lord. On that day, the graduate scale fixation was not placed. My lord. Page 25 is the order, my lord. And 29 is the graduate scale of pay. 26, paragraph 3. And 29.
Okay, we'll take up after the vacation. Today there's no time.
Yes, your lord.
Heard B. Burgastel and the Council for Petitioner as well as MMSH Terangpil and the Standing Council, Secretary Education Department. None appears for the respond number.
It will be, my lord,
Four. List up to the winter vacation.
Lord, it may come on 30th January, my lord.
List the material. Okay, 30 January.
43.
My lord, in this matter, my lord, Advocate General will appear. He is out of session. So can it be taken up the day after tomorrow, my lord?
Not day after.
After vacation, my lord.
My lord, there is very urgency, my lord. Kindly, my last order, my lord. Due to the urgency of the matter, my lord, the 2 academic session already, my lord, lost by the institute, my lord, for which your lordship has observed that endeavor may be made for disposal of the matter, my lord.
Otherwise also, my lord, they do not fulfill the eligibility criteria, my lord.
My lord,
Which
there
is in our review, we have pleaded, my lord.
So we'll have it on the opening day of the thing.
My lord,
Yes, my lord.
absolutely, there is no ground of revision, my lord.
Okay,
The
that's
review,
the
my lord.
thing.
Absolutely, there is no ground, my lord. Only to delay the matter, my lord.
No, my lord.
This petition is filed, my lord. And it is, my lord, evident from the filing of this petition, my lord, that only after receipt of the contempt, my lord, along with the contempt proceeding is there, my lord. Only on receipt of the contempt notice, my lord, this the defective.
No, this is totally wrong, my lord. We filed the review on 5 of October, before Puja vacation. They filed contempt after Puja vacation. Before filing of the contempt, we have filed, my lord. It is
filed, my lord, before, my lord, but it is defective, filed on defective, my lord, and kept defective, my lord. Defective,
Okay.
So, my lord, my humble prayer, my lord, that matter may be fixed before the vacation, my lord.
Before vacation is not possible. Tomorrow also quite a number of cases. The day after the same thing.
Yeah, my lord, there
I'll
is-
fix it on the opening day.
my lord.
On request made on behalf of Mr. D. Saikia. No, Learned Advocate General Assam. List the matter on 6th January.
Yes, my lord.
My lord, can
Mr. M.G. Katir, Learned Counsel for the opposite party. Number
1, my lord.
number 1,
One,
public
yes,
writ
yes.
petitioner.
1 and 2.
1 and 2.
One.
No, opposite party number 1 and 2.
1 and 2, yes, my lord.
One.
Public writ petitioners expresses urgency in the matter.
Yes.
Stop. List the matter on 6th.
My lord, can it be on 3rd, my lord? Can
No,
it be on 3rd,
sixth, my lord,
urgency,
sixth.
my lord.
Third will be no court.
Yes.
This my court. I'll have to
Yes.
hear this.
Right, yes. My lord, may I pray for this matter will come on orders, my lord. So, my lord, may I pray for at 2 p.m. mention, my lord, because
No,
otherwise
that you can mention
at
on the date fix. You mention it.
public.
Obliged, my lord.
44. 44.
None appears for the petitioner. List after winter vacation.
45.
May I please, Lordship? Here in this case, the petitioner is a drop teacher, my lord, and his service will be regularized. Thereafter, by virtue of the order of this honorable court on 14/12/15, they are entitled for regular pension under pension rule of 1969, my lord. Accordingly, GPF account is already allotted, but till date, my lord, his salaries are credited to the NPS account, my lord. So petitioner is before your lordship.
Yes.
Lordship, as you have done their part, the GPF account number have been provided, right? The thing will be.
GPF account is at page 51, my lord.
Okay.
Parent department will.
Okay.
Already provided to him.
But despite the GPF account,
Salaries are credited to the my lord,
Oh.
NPS account.
This is accountant general's note. Yes, Tirang. Some private respondents are here.
Headmaster, my lord, she is not required, my lord. In fact, my lord, your lordship may staff of.
No.
Respondent number 8, my lord. We have already taken steps, my lord. Since it's a simple matter, my lord, the GPF account already there, my lord, but they are still deducting the amount and credited to the NPS account, my lord.
Okay, heard Mr. I Alam.
My lord.
Learn counsel for the petition. Stop. Also heard Mr. D. Das, learned counsel, appearing on behalf of B. Sharma, learned standing counsel, accountant general. Stop. On request made by H. Tirangpi, learned standing counsel,
For 1, 2, and 5.
elementary education department,
Not elementary, Your Lordship, secondary.
secondary education department. How
Elementary,
much time you require?
3 weeks, Lordship.
3 weeks
Yes,
time is allowed.
too much,
I'll
my
count
lord.
after.
After Bihu, my lord.
3 weeks, it will come after people.
Wait.
List on 27th January.
My lord. Obliged.
46. I'm sorry, item 44, my place may be regarded. I was on leg losses. 44.
We have to close the content, isn't it?
No, lordship, because they have see, cyclostyle copy again paste. It was set aside by this honorable.
Okay.
Same copy.
Okay.
Come with same copy. It was set aside by this honorable in the judgment.
Then you want to take time?
I am ready. Whether other side ready, I argue the case.
Assembly just said not here.
After vacation.
Taken after.
Okay, then you change the order. Heard F.U. Barbuya, learned counsel for the petitioner. On request made on behalf of SMT Chishti, learned counsel for the sole respondent, list after the winter vacation.
Obliged. 46.
46, my lord. In this case is for restoration of writ petition, my lord, dispute on non-prosecution, my lord. And there is also IA for condonation of delay.
Where's the IA?
IA, my lord, for condonation of delay, because, my lord, that for communication, some time has been left, and thereafter, my lord, I filed for restoration IA. My lord, it was ought to have filed miscase, but I filed IA, that's why that was withdrawn. And this way, my lord, there is more delay. That, my lord, IA for condonation of delay. And, my lord,
Which one is the IA?
IA, my lord,
Condonation.
condonation.
210 days.
Yes, my lord.
Nayak. Objection.
No objection, my lord. Let him, lordship make.
Right,
Restore,
Mr.
My lord, C. Goswami.
C. Goswami, learned counsel for the applicants. Stop. Also heard Mr. P. Nayak, learned 1 minute. Secretary, Heard H. Tirangvi, Learned Standing Council Secretary Education for the opposite party number 1. 1 and 3. P. Nayak, Learned Standing Council Finance.
PTC.
BTC, then finance will be B. Gogoi.
Lordship may record big.
B. Gogoi is Learned Standing Council Finance for opposite party number 2. And Mr. P. Nayak, Learned Standing Council BTC for the respondents 4, 5 and
5.
6 also. I
6
think.
also. Lord.
4, 5 and 6. Stop. By this application, the applicant is praying for continuation of 210 days in filing the connected
Miss case.
For
Restoration of
restoration of WBC number 3993/2020, which was dismissed for non-prosecution on 5/8/2023. Stop. Learned counsel for the opposite parties have no objections. This court has also perused the course shown in the present IA and is satisfied. Accordingly, the delay of 210 days in filing the connected MC is allowed. IA is disposed. MC also, you have any objection for restoration? Or are there any private parties?
no private party. Yes.
If there are private parties, notice has to go.
No private party. Only BTC and secondary education.
What is the ground shown in your Miss case?
That day was Saturday, my lord. That I overlooked the notification that the court was opening day, my lord. That's why, my lord, my mistake, of course. Saturday, 5th of August, my lord. 5th of August was Saturday, my lord. That's why, my lord, I overlooked the notification that was opening day, my lord. That is why, my lord, subsequently I came to know. I পিছনে মই দেৰিকে গম পালো না। I have stated in my para 2, my lord, in page 12, my lord.
Objection. Heard C. Goswami, learned counsel for the applicant. Also heard MS H. Tirangvi, learned standing counsel secondary education for the respondent 1 and 3. B. Gogoi, standing counsel finance for respondent 2, and P. Nayak, learned standing counsel BTC for the opposite party 4, 5 and 6. Stop. By this application, the applicant, who is the writ petitioner in WBC number
3993
3993/2023
2020
is praying for restoration of the said writ petition, which was dismissed on 5/8/2023 on the ground that as the case
Para
was
2, my lord.
listed on a working Saturday, the counsel for the petitioner could not appear as he could not follow up the cost list, and accordingly the said writ petition was dismissed. So, para learned counsel for opposite parties have no objection. This court has also perused the question in the present application and is satisfied. Accordingly, Miss case is allowed. Accordingly, Miss case is allowed, and WBC number 3993/2020 is restored back to 5. Para. No. In the writ petition, in view of the order passed today in MC number, not IA, MC. So this writ petition is restored back to 5 with its original number. When do you want?
After vacation,
Request made by the learned counsel for the petition list after the window petition.
After vacation, Lord, in the meantime, my friend will serve me a copy, Lord, because if it dispose of file, you have already.
Okay, you serve
Okay,
extra
I'll-
copy to
I'll-
all the parties.
4748.
Please, your Lordship. Lordship, may I kindly peruse the order dated 2/12/2024 passed in IA Civil 3644/24. Your Lordship, petitioner is behind the bar, Lordship, and your Lordship was is to pass an order on 23/10/2024.
Have you met the superintendent of?
Yes, we have filed an IA, Lordship.
Where is the IA?
3883.
Oh, you can't go to sign your pension paper.
Yes, Lordship, because I am in Central Jail, Guwahati. Yes, Lordship's order, if your Lordship can go through the order dated 23/10/2024, when the personal appearance of secretary and the director was.
Where? Which petition?
3906.
This is with regard to suspension.
Lordship. Suspension and another is pension, Lordship.
4006.
Yes, Lord.
Okay. Today is for consideration of the IA.
Yes, Lord.
IA number 3883. Heard Mr. Hard Learned Counsel for the applicant. Stop. Also heard Mr. P.K. Bora, Learned Standing Counsel, Elementary Education for the opposite party. Number 1, 2, 3, and 4. Home and Political.
Government.
No one.
Peace cycle.
Mr. P. Cycle and a government advocate for the respond number 5. Stop. By this application, the applicant, who is the petitioner in WBC number 3906 of 2024, is praying for implementation of the Superintendent of Central Jail, Lakhra, Guwahati, District Kamrup, within bracket M, Assam, as party respond number 6. Correct.
5 is the secretary to the government of Assam, Home and Political Department, and 6 is the superintendent of Central Jail.
As party respond number 6 in the set with petition.
5 is also will be included, Lordship. Respond number 5 will also be included because the secretary to the government of Assam, Home and Political Department, Assam District, because Central Jail is Superintendent Central Jail comes under the secretary to the government of Assam, Home and Political.
Okay. Praying for implementation of of
at page 3, Lord.
This page 3, 8A. Within under say A and within bracket, then as and B within bracket. As party respondents 5 and 6 in WBC 3906 of 2024 on the ground that as the applicant had already filed an IA number 3644/2024, praying for direction to the Superintendent of Central Jail, Guwahati, to escort a petitioner from Guwahati to Golaghat to sign the pension documents for finalization of the pension of the petitioner. The aforesaid to proposed respondents are necessary parties. Stop. On consideration of the question, this court is satisfied and accordingly pray for IAS, the IAS allowed. And in WBC number 3906, you say, in view of the order passed today in so-and-so, let so-and-so be included as party respondents, 5 and 6. Now, the government advocate is not there. Now, we have to give him directions.
Uninformed,
Just does Mr. P. Saikel, then a government advocate, enters appearance on behalf of the newly imputed respondents 5 and 6 and prays for a short time to enable him to receive instructions. Stop. Prayer is allowed. List after the window vacation. You inform P. Saikel?
49.
Oh, petitioner is also directed to file an amended cost title within a period of 1 week from today.
It is a lordship.
Huh.
Lordship, in this matter, any application for extracting out of name of private respondent number 4 to 10 from the rate petition, my lord.
4 to 10.
Yes, my lord. Private respondent, my lord.
They are not required parties.
No, my lord.
Okay, heard Mr.
R.I. Bhuya.
R.I.
Bhuya.
Bhuya, learned counsel for the petitioner, for the applicant. Also heard MSH Tirampi, learned standing counsel, secondary education. For the respondents, one for the opposite party, 1, 2, and 3.
Yes.
Stop. By this application, the applicants were the petitioners in WC number 4002 oblique 2024. How many petitioners are there? 7.
7, my lord.
How many applicants are there? 7. Okay. Are praying for deletion of the respondents 4 to 10 in WBC 4002 of 2024 on the ground that the said respondents have not been selected against any vacant post and they are also not involved in any selection process. No. On the ground that the petitioners had filed a writ petition to appoint the petitioners as headmasters in the respective schools, considering their seniority and length of service. Stop. However, it has come to the knowledge of the applicants that the respondents 4 to 10 in the writ petition are not selected against any vacant post, and they are also not involved in any selection process. On that ground, the applicants have no cause of action against the respondents 4 to 10. Stop. Para. On consideration of the cause shown in the present application, pray for this IAS allowed. Para. Writ petition. In view of the order dated so and so, let the names of the respondent number 4 to 10 be deleted as party respondent in the present writ petition. Petitioners are directed to file a amended cause title within the period of 1 week. You want time?
Yes, sir.
MSH Tirangbil and the Standing Council, Secondary Education Department, press for 3 weeks time to file counter affidavit. Praise Allah. List up to 3 weeks.
50.
Please, Lordship. The applicants, Lordship, here, they have already filed a writ petition, Lordship, and this IA Lordship has filed, Lordship, to get the similar benefit of a division bench judgment, Lordship, that is morally Sheikh, Lordship.
Huh?
In that case, Lordship, the Honorable Division Bench held that the tutors, Lordship, they are also eligible for the regular pay scale, Lordship.
Oh, in that judgment,
Yes.
the respondents were given 6 months time
Yes, Lordship.
to take a decision.
To initiate the process to, Lordship, give the process.
To take a decision whether the tutors also can be given the same scale of pay as that of the teachers. That 6 months time period is yet to elapse.
But no, here, it says they are eligible. But Lordship to take initiative.
That 6 month period is yet to elapse.
Yes, yes, that is correct, Lordship.
Now, why are you in a hurry?
So we have already filed a petition, Lordship, to regular our post to the category teacher, Lordship. But in the meantime, Lordship, we have some lapse of Lordship qualification.
Heard, Mr.
Yes, Hawk, Lordship.
Learned counsel for the applicant, issue notice. Mr. P.K. Bora, learned standing counsel, elementary education appears for the respondents.
1, 2, 3,
1, 2, 3,
6 and 7.
6 and 7, and press for 2 weeks time to file objections.
3 weeks.
3 weeks time to file objections. Praise allowed. List after 3 weeks.
Lordship, on date, Lordship, can.
Yesterday, do you remember I fixed the case after 8 weeks?
Item 5 and 6.
51 hearing.
Plus.
Hanik, next year.
Some of the time after Bihu.
After B.
The first part I may not be there.
As Hanik, learned counsel for petitioner, as well as H. Terangbil and standing counsel, Secondary Education Department. List
Fixed
the
date,
matter
a fixed date may be given.
after Bihu. Okay. Oh, no. 28 is a hearing day. 28 January. Finish.